order directing the executors to pay a sum of 1 crore and not to the beneficiary is tenable in the eye of law. Very short matter, my lord. The matter was
Matters take long
to
time when
mediation,
they start.
failed, my lord.
So we can't
Kindly appraise to some extent, my
No, ma'am. Sorry, we can't give precedence because short matters become long when they start.
It's very short matter, like my lord.
We understand,
Okay.
but
We have, sir, I have served the
short is very relative. So, columnist.
Yes, sir.
Apple is set at 2. Yes. What is it? Yes.
My lord, this is the CNE matter, my lord. There are just some minor typographical errors, my lord,
What are the
that may need to be
corrections?
corrected.
Yes.
My lord, this
What
is the judgment. May I hand over?
My lord, may a copy be also given to us?
I
Will
don't.
be submitting on this?
So you can just share it. Very easy.
Yes.
My lord, at page 16, para 49, my lord.
Yes.
My lord, second last line, and the evidence of Mr.
Thing will be BJ, B.
Yes, my lord.
And WP, not WP.
Yes, my lord.
Very well. And
my lord, page 65, my lord. Para 199, my lord.
why do people pass so long judgments? Unnecessarily. Yes, we have seen. Tell her.
Yes, yes.
2022 and para 201.
Yes.
In of course.
This can.
So no serious opposition.
No. No opposition at all.
Well, well, short order. It is rightly pointed out by learned counsel for the appellants that in the judgment dated January 21, 2026, comma, certain inadvertent errors cropped up, comma, which are as follows, colon diye, Roman 1, in paragraph number 49, comma, the name of Mr. B-I-J-A-Y, Bijay Kumar Bagri was erroneously mentioned as Vijay Kumar Bagri. Full stop. In paragraph number 50, comma, WP number 46471 of 2006 has been transcribed as WPA बोललाम की? हाँ, has been wrongly transcribed as WPA number, the same number. Full stop. Again, comma, in paragraph numbers 199 and 201 of the said judgment, comma, EC number 81 of 2022 has been erroneously transcribed as EC number 81 of 2020. Full stop. Next para, the above errors we deemed to stand corrected accordingly. Full stop. This order may be treated to be a part of the judgment dated January 21, 2026.
My lord, along with para 199, my lord, 201 also.
201.
Same error.
Achha. 199 and 200 बोललाम.
201, my lord.
Very
Grateful, my lord.
Thank you. Please. Hey. এটা হচ্ছে আমার একটা. Yes, please.
I'm led by Mr. Thakkar in this matter.
Little bit of arguments and written notes. Start a little bit now.
Man.
You are not panting a few minutes back. You are
I was.
deliberately panting.
No, my lord, I'm not. I'm not. I would never shy away from it. I am panting, my lord. It's the fault of my fitness, nothing. My lord, on the last occasion, my lord.
Yes.
My lord, in some, my lord, the argument made by my lord the other side was first, my lord, that the sum and substance of the orders impugned before my lords was merely procedural and not, my lords, substantive. Particular note was made with respect to such orders being mere extensions of time. My lord, our answer to that is, my lord, simple. First, my lords, in the order dismissing the execution petitions, there was no time set. The first time a time limit came in for the registrar to execute was, my lord, in the first impugned order before my lord. Furthermore, my lord, A plain reading of the impugned orders would show that they were not mere extensions of time. First, my lords, as my lord is aware, several objections had, my lord, been filed by us. My lord, such objections were noted in the impugned orders, and not merely just noted, my lord. The impugned order, in fact, set a time then for the registrar to dispose of, my lord, my objections. So, my lord, this is important on two counts. The first, it was not a mere extension of time. And second, it was, my lord, a blessing, if I may use the word, or, my lord, a ratification of what we have shown, my lord, are illegal and, my lord, extrajudicious, my lord, actions of the registrar in that regard.
So those tantamount to directions on the registrar to decide those objections,
My lord.
Which is dehorsed law.
Which is dehorsed law and was a ratification of the same. My lord, I am, my lord, led by Mr. Thakkar. My lord, maybe.
My lord, the two judgments, may I just come to the two judgments and then address? Two judgments were cited before your lordships. My lord, one was a judgment of the Honorable Supreme Court. In that case, my lord, time was fixed for payment of court fees. Court fees was not paid within the time fixed. AIR 61, Supreme Court 882.
Yes.
Can you see paragraph 5? And you see the second sentence there. The application for extension of time was made before the time fixed by the court for payment of deficit court fee had actually run out. So an application was made within the time which was available for payment of deficit court fee. But because of the peremptory order, it was not considered. Then, Malad, kindly see what was the question. The short question is whether the High Court, in the circumstances of the case, was powerless to enlarge the time, even though it had peremptorily fixed the period for payment. And then your lordship will kindly see that 151 read with 148, 150 and 149. The Supreme Court held that the powers are there. That is at the next page. So, my lord, on the basis of this judgment, it has been argued that even if the court becomes functus officio, it still retains the power to enlarge time. First point is, my lord, no time was fixed by the order by which the execution case was disposed of. Second is, by relying on this judgment, the respondent admits that the list had come to an end. Parties are ad idem that the list had come to an end. It is their case that this is a procedural order which could have been made akin to the order which is made here, a procedural order which could have been made to enlarge the time. Therefore, it is not their case that the list had not come to an end. Similarly, my lord, the judgment of our court, the division bench. In this case, the time to fix certain departmental proceedings. This is 2008 FCC Online Cal 269. Can we have that, please, my lord? Paragraph 2. This is an application seeking extension of time to complete the departmental proceedings, which was allowed to be completed within 2 months by the order dated so-and-so, when the appeal of the delinquent employee was disposed of without interfering with the departmental proceedings, which was the subject matter of challenge. So the Honorable Court, my lord, disposed of the appeal, directing the departmental proceedings to be completed within 2 months. Now kindly turn to the next page, please, my lord. Paragraph 2. About 10 lines from the bottom towards the right hand side, the time limit. My lords have. The time limit was fixed in view of the pendency of the matter. Now kindly see, it is a settled law that time limit as is fixed by the court to complete anything by an order comes within the field of procedural part of order and not on subjective adjudication part of the order. The adjudicatory part was whether the departmental proceedings should be allowed to continue on merit. Such adjudication was done by this court, disposing of the appeal by not interfering with the impugned judgment under appeal passed by the learned trial judge, whereby and whereunder the initiation of the departmental proceeding and its continuation was not interfered with. The extension of time to complete it is nothing but allowing the time limit to complete a procedural matter, and it is not coming within the field of an adjudication of the matter on merit. Similar, this judgment is also an authority for the proposition that procedural timelines can be extended. And this is in support of their argument that these were merely procedural orders, a fortiori made after the list is disposed of. It is not their contention that the list was pending when the subsequent orders were made. And that is why the reliance on these two decisions. So parties are ad idem that the list, being EC 255, was disposed of. Now the issue is, before your Lordships, Millard, whether the impugned orders are in the nature of procedural orders or orders made post-adjudication. That is the short point. Now, Millard, if your Lordship sees the orders, the other argument now, which is advanced, is that Order 21, Rule 3 and 4, court means, can you see Order 21, where the language used is court? That has been urged to mean that court means the registry of court, which, with the greatest of respect, Millard, is not what the rule provides. Order 21, Rule 34.
Yes.
Can you see? Where Order 21, Rule 3. Order 21, Rule 34, Sub-Rule 3. Where the judgment debtor objects to the draft, his objection shall be stated in writing within such time, and the court shall make such order approving or altering the draft as it thinks fit. Now, this has been urged to say that the court here should mean the registrar of the court.
Contrast it with, suppose, 4.
Kindly see 4.
Where it has been specifically said that or such officer.
Yes, or such officer for the limited purpose of execution of the document. Obviously, Manoj, the learned judge is not going to execute. So the ministerial task of execution is delegated to the officer of the court. Not even delegated. The law itself provides for it. Court will direct X officer to execute. But the fact that 3 cannot be an officer of court is because 34(3) is an appealable order under 43(1)(I). And it means court. Court and registrar or an officer of court cannot be used. Are not synonymous, my lord. Now, my lord, it has been urged before your lordship that while passing a decree of conveyance, a decree for specific performance, your lordships nor the arbitrator would be expected to set out the conveyance. The conveyance would not form part of the decree or award, and there can be no cavil with this proposition. And that is where 34(1)(2)(3) come in. That once the decree is for execution of a document, then the document has to be settled by the executing court, not by the court which passed the decree. The decree will never have the document. The decree will simpliciter say, even if it is a decree made by a court in a suit for specific performance, the decree will simpliciter say specific performance granted, conveyance to be executed, in default registrar to execute conveyance. That is the simpliciter decree. So I do not say that the award of the learned arbitrator granting specific performance should have set out or should have given a draft of the conveyance. That is not what the law envisages. The law envisages under 34(3) that when such an award is made or such a decree is made, the decree holder shall provide a draft of the conveyance, which will be approved by the court, that is the executing court, and thereafter put into registration. So the learned arbitrator, with the greatest of respect, has not erred in not providing the draft of the conveyance. He's done perfectly right, my lord. Then, my lord, kindly see. The next objection was that objections with regard to the document is not taken in the memorandum of appeal. That I have said already, my lord. That is part of another reference proceeding before the learned single judge in chambers in terms of the provisions of our original side rules, which provide that any order made by the registrar can be challenged before the judge in chambers. So your lordships, I am not beseeching your lordship to sit in appeal over any order made by the registrar while disposing of my objections. That is subject matter of another challenge. The limited challenge before your lordships is whether the 3 orders are made by the learned judge after becoming functus officio and the legality of the very orders. Now, my lord, the next argument which is advanced is that by placing the reports before the Honorable Court, the registrar has taken the approval of the Honorable Court, or the court was monitoring the registration of the document, and that is why the court provided the map in question. My lord, the registrar was directed to finalize the conveyance. None of the orders impugned would show that the learned judge has applied his mind or rule, has not even has even applied his mind far to speak of rule on my objections in terms of 34.3. None of the orders would show. Neither are the objections considered, nor is there an order made rejecting the objections. In fact, the order is made directing the registrar to dispose of the objections within the time frame fixed and to finalize the conveyance. The learned judge did not settle the draft of the conveyance as was required under, stipulated under 34.3. So this also, my lord, with the greatest of respect. Then, my lord, your lordships was shown original side rules, chapter 38, rule 46. Kindly see, my lord, chapter 38, rule 46 of the original side rules once, please.
তলায় বোধহয় আছে নাকি ডান দিকে তোমার ডান দিকে একদম তলা একদম তলা তোমার বাঁ হাতে তলা
Rules 46.
46 একদম ডান দিকে কম্পিউটারের সামনে একদম তলা এইটা না না তোদের সামনে
Chapter
38 এক মিনিট this chapter
This 30.
part 46
Chapter 38, rule 46.
Oh.
That is, my lord, to show that the power under the rules is there to enlarge or abridge the time. There's no dispute with this proposition. The issue is whether any time was fixed by the order disposing of the EC, directing the registrar to do the job within a time. Power is,
relates back to your first argument.
This
There
relates
was no
back-
time fixed in
there
it.
was no time fixed. Then, my lord, kindly see chapter 17, rule 28 was shown to your lordships, my lord. Yes, this was shown. I did not place reliance on this. This was shown.
Chapter 17 rule.
Rule 28 was shown to your lordships. Kindly see.
I was told that you had, sir.
I had not shown this, sir. You were misinformed. I had not shown this.
I was told that my learned friend had relied on that rule. That's why
you
that I brought your lordship's attention.
I had not. This rule was shown. Kindly see. This, I would not have shown this much. Kindly see. Anyway, kindly see chapter 17, rule 28. The acts directed by the court. The acts direct, kindly see, execution of document or endorsement of document, form of endorsement or execution. The acts directed to be done by the court under order 21, rule 34.5, not 34.3. This was shown by the respondent to show that this could be done by the registrar. Yes, there is no dispute. The registrar could have simpliciter executed the document. 21, rule 21, rule 34, sub rule 5 provides only for execution of the document.
Here it's a scenario under 34.3.
Yes, it's a scenario under 34.3. This rule is not applicable.
Might have been to contrast the two you had cited. We don't remember.
Beg your pardon?
It must be there in our notes.
Yes, yes. This was.
Might have cited this for the purpose of contrasting it.
No, my lord, perhaps I had not cited this because I have written my learn.
We get your answer.
Your lordships will get that. Now, my lord, kindly.
Even if there is no question, we get the answer.
Now, my lord,
Yes.
so the decisions I've dealt with, these were their submissions.
Hmm.
Now, my lord, if I may just be permitted to argue against myself. Argue against myself to the extent that the learned judge was not functus officio. Let us take it in a position where the learned judge was not functus officio, whether these orders could have been made. And may I, my lord, with the greatest of respect, beseech your lordships to test the legality of these orders, assuming but not admitting that the learned judge was not functus officio. Kindly have the order at page 122, please, my lord. Which is the first impugned order.
Yes.
Now, my lord, only limited to whether these orders are in accordance with law, my lord. Assuming but not admitting that the learned judge was not functus officio. Kindly see the second. From the report, it appears that he could not execute the deed in favor of the award holder, since the award debtors have filed 13 objections before the registrar, and for that reason, he could not finalize the deed. So, one is objections, two is finalization of deed, which is required to be executed in view of the judgment and order passed by this court and so and so. Now, kindly see the next. He also prays for some time to finalize and register the deed of conveyance in favor of respondent number 2. So, 13 objections and prays for time to finalize the deed. Then it is also informed that hearing of the objections filed by the award debtors have already been concluded for final disposal. So the learned judge by this order now extends the time on the prayer made by the registrar to dispose of my objections and finalize the deed.
Mr. Thakkar, taking your case against you a bit forward,
Please,
I mean, it was rather indicated by Mr. Kaur that this culminated in the next order. So, by this order, a report was directed to be placed before the learned judge.
Please,
so we are also putting it against you.
Please, my lords.
That report contained those objections.
Please, my lords.
Learned judge asked for a report on that, on those objections.
Please, my lords.
Let us suppose that the registrar was directed to decide and whatever his take on the objections.
Yes, please.
But the next order, 19th December, the very next 124.
Please, my lords.
Now, upon careful perusal of the report as submitted before this court finds that a draft deed along with map has been submitted before the register, but it could not compare with the record such and such, then the map is directed. So, can't this be argued to be an adjudication on those objections in the sense, yes, you are right, the 13 objections do not find place here, but the draft was placed before the learned judge. We are thinking about 34.3.
Please, my lords.
Placed before the learned judge.
Please,
learned judge found certain omissions and certain things. To resolve that, he directed it to be compared to something.
Please, my lords.
So, can't this be stated to be an exercise under 34.3?
Please, my lords. Two things I want to address your lordship on. Kindly see 19 December order.
Yes.
It is limited to the issue of the map. It does not talk of any recitals in the draft being objected to and the decision thereof.
So still there is no adjudication on the objections.
On the which you are
adverting to that also.
No, there's no adverting. It is the learned judge at the highest finalize the draft to the extent of the map. To the highest. I'm sorry, at the highest. The registrar expressed his difficulty in incorporating a map which did not form part of the decree, which did not form part of the order disposing of the execution case. To that extent, this is an adjudicatory order, only to the extent of the map, but not on the terms of the conveyance, on which there were these objections, which your lordship has seen. Order number 1, the registrar has recorded that you have raised objections on the very terms of the conveyance, which is a 34.3. So 34.3 now in this case has two parts. One is the objections on the terms of the conveyance, one is on the map. At the highest, the map has been adjudicated upon, but on the terms of the conveyance, there is no adjudication. That remains and was ultimately decided. It is a matter of record that these objections were disposed of by the registrar only. It's a matter of record.
Your objections cover the terms of the contest.
The PS 286, your lordship saw order number 1. Objections were raised on the terms of the draft conveyance, which the learned judge has also noticed. So, my lord, I say that the first order, with the greatest of respect, directs disposal of objections which the registrar was not competent to. Second, directs the registrar to finalize the deed of conveyance, which also the registrar was not competent to in law. So the first order, with the greatest of respect, my lord, suffers from 2 illegalities. Now kindly come to the next order, which is of 19 December. The learned judge directed the registrar to compare whatever the schedule with Exhibit C22. This is an adjudication possible in terms of 34(3). Now, my lord, to justify inclusion of this map, the respondent took your lordships through 6 pages of the award. Your lordships have those pages noted. I'm not troubling your lordship with those pages. Your lordship will go through those pages. Your lordships will not find reference to Exhibit C22 in any of those 6 pages. In A, the order impugned incorporating Exhibit C22 does not refer to any page of the judgment. I'm sorry, any page of the award, which is now a decree. So Exhibit C22 has been incorporated without any reasons. And reasons are the soul of any order. So if this is an adjudicatory order under 34(3), then it lacks reasons for incorporating Exhibit C22. A. Now to justify this, your lordships as the appellate court can supplement reasons, even if I bow down to that proposition. As the first court of appeal, your lordships can supplement the reasons, even if I take it to, again arguing against myself. Your lordships will find that the 6 pages of the award which my learned friend has referred to do not refer to Exhibit C22 at all. And I put my case slightly higher. In this award running into about 200 odd pages, Exhibit C22 is not even referred to once in the entire award. These are the 6 best pages which could have been culled out from the award. Do not refer to Exhibit C22. The entire award does not refer to Exhibit C22.
It said that in terms of your
whatever title I have got, I have to pass on.
whatever title.
Whatever title I have got, I have to pass on because of the undertaking which was given that he shall not claim title in the proceedings.
So whatever title is passed on, I mean, how can that be ascertained without looking into that document?
I don't know, madam. Because the learned arbitrator, now what the executing court is doing, it is not only going behind the decree, because the decree does not refer to Exhibit C22, it is going into the records of the suit, which do not find mention in the decree. If Exhibit C22 had indeed been referred to in the award, my learned friend would not have troubled with those 6 pages, which even then do not refer to Exhibit C22. All that was required to show your lordship was that, see, the learned arbitrator has accepted that this is C22 which has to be transferred. But the learned arbitrator does not refer to Exhibit C22. So that is why the illegality creeps into the second order. C22 is going into the records of the suit by the executing court. And that too without any reasons whatsoever. Then, my lord, again, the learned judge does not say that you incorporate Exhibit C22. The learned judge directs the registrar. Now kindly see the third order. Again the same illegality that you compare. It is not a fiat of court that C22 has to go in. The adjudication would have been by reason of a judicial fiat that I hold that C22 map has to go in. But that is not the judicial fiat in this order. The fiat is learned SBPL is directed to assist the learned registrar to compare the deed with the map. So again, the judicial function of deciding on C22 is left to the registrar. Again, 34(3) is violated. Learned registrar original side is, now kindly see, directed to comply with the order passed by this court for registration of the deed after proper verification of the said document. So whether C22 matches with the schedule, matches with the award, all that is a delegation of judicial function, which is again left to the registrar. All that the learned judge has done is, he has identified a document which does not form part of the award. And he's again directed the registrar that you compare with this. And the award holder is directed to assist the registrar to compare the deed, that is the draft conveyance, with the map which he has given, and the schedule of the award with exhibit C22. So there is no determination, again, with the greatest of respect. Again directing the registrar. So my lord, even if this, just digressing, I was taught by a barrister who was the QC, now they are KC, and I was assisting in setting aside an award. They call it challenge to the award under the English Act. They said our judges are taught to make the awards, our judgments appeal proof. And therefore all the alternatives are given. If I be wrong in this, then this. If I be wrong in this, then this. And one matter, your lordships, I lost a 34 before my Lord Justice Bhattacharya, your lordship, has adopted the same reasoning, that even if it be that Porel Das matter, timelines, your lordship has dealt with it in 3 stages. So, my lord, so here, my lord, arguing against myself, my lord, I say that even if it be said that is functus officio, is not functus officio, even then the orders are, my lord, perhaps not in consonance with law. Those are my respectful submissions, my lord. The notes was to be filed, I'll file it within the course of the day, my lord. Only grant us leave to.
The court will be filing on your file.
I'll file it. Just a few corrections to me. I'll file it within the course.
The written notes of arguments filed by the respondent be kept on record. Full stop. On the prayer of learned senior counsel appearing for the appellant, comma, leave is granted to the appellant to file its written notes of arguments during the course of the day. Full stop. Hearing is concluded. The matter is reserved for that. যে আর্গুমেন্টস গুলো আছে ওতে ঢুকে যায় নোটে আমার হ্যাঁ ওই এটাও করে দিই হ্যাঁ এক্স্যাক্টলি থ্যাংক ইউ Yes.
My lord, I am being led by Mr. Mitro and Mr. Bhattacharya. Now, this is that issue which involved the question of Section 9 and Section 36. We, on last day, Mr. Mitro mentioned this matter before my lords in the presence of the other side, and we made a request if it comments to my lords, because otherwise we risk losing a forum. If if it comments to my lords may continue the interim order and send it back to the first court.
Well, the question of maintainability will of course have to answer to that. My learned don't go back and argue the same question again before the learned.
No, that's the point. We do not want to lose a forum on the question of maintainability.
No, my lord. That question of maintainability has been raised. It has been held against me. That is the appeal. My lord, that has to be decided by your lordships, and your lordships have heard the matter substantially.
So the maintainability has been decided on the question of applicability of Section 13, not the issue of whether whether at this stage a Section 9 will be applicable or not. A post-award Section 9, whether that will be applicable even after the enforcement, even after in their enforcement proceedings, the enforcement stands negated and there is an order of the first court stating that there is no award. So that point of maintainability we would like to.
May I just
want to lose a forum on.
May I just clarify this? Well, the learned single judge held that since you have already said that, my lord, this, my lord, conciliation proceeding or mediation proceeding has matured into an award. And, my lord, the learned, my lord, executing court, my lord, did not agree with our contention. Then, my lord, we have adopted a stand that this is an award. And, my lord, we have also, against the order of the learned, my lord, judge in the executing court, filed an SLP, my lord, which has been admitted, which is being heard. Now, my lord, in the meantime, because they were trying to deal with the property, my contention with your lordships was that, my lord, so far as the Section 9 application is concerned, it is maintainable, because as my learned friends say, that my learned friends' contention, it has not become an award. In that case, it continues to remain an agreement with an arbitration clause, in which case I can, my lord, ultimately exercise my rights under Section 9. If in any event it is, my lord, held to be an award, an enforceable an award, even then, my lord, because it has not been put in the process of enforcement, I am entitled to maintain a Section 9.
That question is actually linked with the question which was raised in adjudication.
And, my lord, that is
It's an
exactly
offshoot.
the question, my lord, on which the learned single judge has, my lord, dismissed my petition.
Yes, now that is actually where my predicament lies. What is happening is because my lord recalls, we from first day we are saying that they have to now elect. And unfortunately, when we go for a Section 11, they come and resist it
It's a
there.
part of the arguments which Mr. Shah is making.
Hmm.
And that issue has been adjudicated. The primary issue has been adjudicated. What you were saying is an offshoot of that and is correlated with that.
Yes.
If that is held in their favor, the Section 9 maintainability will be one way, and if otherwise, vice versa.
Yes.
So it's not a different issue, actually, Section 9 maintainability. It's a part of the issue which was decided by the and since they have preferred this appeal, it's their option actually. If they want to go ahead with the appeal, we'll hear them and decide it.
Because, my lord, when
In any event, that will be prima facie at this stage, and
No.
we'll make it clear that it's prima facie at this stage, whatever that means.
No, obviously, if
no,
my
well,
learned
I
friends
have
do
already
not,
made my arguments.
do not
Mr. Mitra
concede
was
to
in the
this, then we will have to argue.
No, no,
We
well,
understand it is
Better
their
to
appeal.
argue.
Well,
This
your lordship has
under
heard this matter
consensus, we cannot do
substantially.
that. He has argued at length.
So I'm being led by Mr. Datta.
He anticipated this. He knows the code.
No, my lord, I heard Mr. Shah, my lord,
On the
saying,
last occasion also, yes.
yes. So, my lord, lordship was hearing Mr. Mitro on the point that whether a post-award Section 9 is, my lord, maintainable after the period envisaged under Section 34(3) of the 1996 Act is over. My lord, kindly take the Arbitration Act and comes to Section 9.
পাতলা লাল বইটা ওইটার মধ্যে থাকবে দেখাবো ওনারা ওইগুলোর মধ্যে সেকেন্ড থার্ড দেখা যাচ্ছে We'll come to Section 9.
My lord,
Yes, Mr. Look,
I'll place Section 9, my lord. 1.
please.
A party may, before or during arbitral proceedings,
Boils
we are
down
not
to before
concerned with,
Boils down to before it is enforced.
yes, at any time after the making of the arbitral award, but before it is enforced.
So what is the connotation of enforced?
Now, whether this
Whether
expression
putting it into
enforced,
execution is
whether this expression enforced would mean the actual enforcement of the award till the fruits of the award are realized, or whether this enforced expression enforced would mean a party applying for enforcement after the period under 34(3) is over. Now, this enforcement has to be, my lord, in terms of Section 36.
yes.
Now, my lord, I read, my lord, once again, my lord, 9(1), one more expression which I felt is of some significance.
Absolutely, yes.
At any time after the making of the arbitral award, but before it is enforced in accordance with Section 36, apply to a court. So, this, my lord, according to me, is only, my lord, covered for that window of, my lord, the award being published, the 34(3) period being over, as in 3 months and 30 days. And thereafter, if you have enforced, you can't come to 9. If you have not, you have lost your chance.
So the verb enforced depends on the perspective from which you see. Either the award holder, it is enforced by the award holder, or it is enforced by the court. So it depends on the perspective of whether you see it from the perspective
My
of
lord,
the
I see it from the perspective of the award holder.
award holder. Yes.
Award holder, because this is an enabling provision for a party to apply. Therefore, I see it from the, my lord, perspective of an award holder.
Putting in the execution is
Enforcement.
I enforce.
And when you enforce, and I have also seen my lord's single bench view,
my lord, in that matter, lordships had indicated on the last day that in one of the matters, lordship held that some of the provisions of Order 21, Rule 99 to 101.
Otherwise, that will come in.
So I have, my lord, because lordships had indicated, we have also, my lord,
Open a
considered.
new.
Yes,
which is
because
not
that is
possible.
again, lordship's view was because that is akin to a separate decree. It's a separate decree.
Scheme decree. So therefore, this scheme of things in this act, because you see the appellate forum is the executing court, to cut short so that least interference is there.
My lord, my lord, I'll be very honest with your lordships now. My lord, there are divergence of view on this point.
Suppose, just think it clearly. I mean, without any views. Just if the 36 court entertains, if that enforced means something more than a pure execution, then all the powers of Order 21 come in.
Yes.
Then if a challenge is preferred by a third party register, then that will have to be adjudicated. Then the 36 court is usurping the power of the arbitrator. In fact, there is a fresh adjudication. There will be not even a parallel, a hierarchical confusion there. Then that first adjudication of that will be by the 36 court, against which then what will lie?
My lord,
An appeal lies.
with utmost respect,
You
I would
just
like to, my
frustrate
lord,
the scheme of the act.
no, with my lord, respect, my lord, I would like
Yeah,
to
we know what
differ.
by respect is. Please proceed.
My lord,
I say with utmost means most insult.
My lord,
Anyway.
kindly takes two more provisions, my lord. Section 34 I want to place, and then I come to section 36, my lord.
Absolutely, yes.
Recourse 34, my lord, 1. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. I am not placing subsection 2, kindly comes to subsection 3. An application for setting aside may not be made after 3 months have elapsed from the date on which the party making the application had received the arbitral award, or a request, or if a request had been made under section 33 from the date on which that request had been disposed of by the arbitral tribunal, provided that if the court is satisfied that the applicant was prevented by sufficient cause from making the application within the set period of 3 months, it may entertain the application within a further period of 30 days, but not thereafter. So this is the terminus point, my lord, for an award to become enforceable. And now if I read this with, my lord, section 9, that part, subsection 1, before it is enforced in accordance with section 36, I am trying to correlate, my lord, these two, my lord, provisions to mean that, my lord, this enforcement, right of enforcement kicks in the moment the period under 34(3 as envisaged by the act is over. My lord, otherwise, my lord, this section 9(1) could have, my lord, legislature in its intent could have, my lord, only stopped at, my lord, award. This expression, but before it is enforced, may then, my lord, mean a surplusage. Because then if I read it without this, my lord, expression but before, then how does it stand? A party may...
No, there may be a meaning to that. I mean, if it is enforced already, taking the other view, your opposite view, if it is already enforced, then there is no scope of any section 9, because there is no, the arbitral agreement.
Yes, if it is already enforced, there is no scope of section 9.
Exactly.
So,
So
Lord,
therefore, these words might have meaning on that count also.
their lordship means that before final enforcement.
Final enforcement, then there is no scope of any section 9 does not operate.
Yes.
Because there is no the arbitration agreement has reached a culmination.
But even if it is, my lord, even if it was not there, a section 9, post-award section 9 would only as an interim measure lie to preserve the fruits of the award till such time there is an enforcement. My lord, this enforced, but before it is enforced, expression.
If it is not there, then after the making of the arbitral award,
after the making of
no
the
sense.
No,
it will be forever.
After the making of the arbitral award apply to a court, it would, my lord, the terminus point then also would mean, my lord, actual enforcement within the meaning of section 36.
There would be no terminus then, if those words before it is enforced were used.
There won't be, my lord, any question of a section 9. If it is already executed, no party would come to court with a section 9.
For that, to cut that out,
yes,
it has been put in specifically. But after making of the arbitral award, if the language was a party may before or during arbitral proceedings or any time after the making of the arbitral award, then the legislature could only say the at any point of time you can.
Then the legislature could also have, my lord, said, my lord, but before it is finally enforced. The legislature has not used the expression finally. Legislature has left it at enforced. And this now, my lord, we are only, my lord, trying to persuade your lordships to hold.
Accepted, Mr. Datta, then it would be, the language would be, but before the time for filing 34, or before the time for filing enforcement arises, or time for filing 34 ends.
Yes.
Something like that. It's not there. It's clearly, but before it is enforced. What is enforced? It qualifies award. So the award is enforced in accordance with section 36.
Yes. Now let us, my lord, come
Not,
to say,
not that, but before an application for enforcement is filed under section 36. Not that. It could have been as simple as that. Before an application or a proceeding is taken out under section 36 or something.
my lord,
similar
kindly
like
comes
that.
to section 36 once, my lord.
It is correlated with 34.3.
My lord, kindly comes to section 36, where the time for making an application to set aside the arbitral award under section 34 has
It is correlated
expired.
with 34.3.
This is
Doubt on
correlated
that.
with
No,
34.
yes, yes.
Then subject to the provisions of subsection 2, such award shall be enforced in accordance with the provisions of the code. Now, this expression, such award shall be enforced, my lord, I am trying to, my lord, make, my lord, a meaning out of this, my lord, and incorporating that in section 9, where it says in accordance, enforced in accordance with section 36.
Absolutely.
So shall be enforced means the moment, my lord, according to me, my submission is the moment I file an application, my lord, I take the first step to have the award enforced. And the moment I do that, my lord, my right to file another post award section 9, these parallel remedies are not there, my lord. Otherwise, it would mean I can file a section 36. Under the sun, I can ask for any order in the before the executing court, whatever I am entitled to in law. And I can also file a post award section 9, though I have filed an enforcement application. This possibly the legislature never intended.
Mr. Datta, the parallel remedy theory falls flat because 36 to only contemplate a stay of the order, nothing more. Section 9 is much wider. Receiver, so many things. Order 38 will 5, order 40, order 39. So many things clubbed into one. So it's a wider remedy in aid of the execution maybe. So therefore, there will be no remedy apart from seeking a stay of the award. No other remedy could be sought. See, you have an award, right? You put it into execution. It has not yet been enforced. In the interregnum, then you have no remedy but only to seek this stay of the award under 36.2. That would be the interpretation. So we have to give an interpretation, a liberal interpretation, in the sense that the parties, the award holders' rights should be protected during the in the interregnum. Even the award debtors' rights may be protected. Section 9 gives both of you rights. So therefore, that protection would be taken away by us if you interpret it as you are saying. Only 36.2 would be the remedy then. We are also thinking on that, in that lines. Because 39 is a blanket remedy, so many things put into one. Then only 36.2 stay will be there.
My lord, if I may take over from
That
Mr.
would have no remedy during enforcement, in aid of the enforcement.
My lord, kindly permits Mr. Mitra to take over, my lord, because he has some, my lord, points to make, my lord, on this. Maybe I am not in a position to, my lord,
No, obviously yes.
express myself, my lord, so clearly like what Mr. Mitra would do, my lord.
No, but the only thing I was wondering whether I had argued this on the last occasion. I wondered, are we really required to go into this? If I may ask myself the question. Now, my lord, kindly look into their, my lord, application under section 9. It proceeds on the basis of, my lord, award. I can show your lordships, my lord, different, my lord, paragraphs of the application.
Proceeds on the basis that there is an award.
There is an. Now, my lord, which, my lord, that is why my first submission before your lordships was because there is one, my lord, slight, maybe a few lines, my lord, in one paragraph which says even otherwise, this is an agreement. That is why, my lord, on the first day I submitted before your lordships that, my lord, they have to elect. Whether it is, my lord, a section 9 application simpliciter or, my lord, it's a section 9 application on the basis of an award. That, my lord, election they have to make. Now, my lord, if my lord they say that my lord it is an award and it is my lord an application section 9 application post award, my lord, in my respectful submission, today, my lord, a competent court of law has held that it is not an award. That is an issue pending before the honorable. They preferred an appeal. The appeal was not entertained. The matter is pending before the Supreme Court. Today, my lord, there is, and my lord, your lordships, in your lordships interim order, your lordships have also recorded that your lordships are not in appeal from that order holding that it is not an award.
The Section 34 court held that.
Sorry, my lord.
Section 34 court held
Your
that.
lordship held that. Your lordship held that. While
We, as under Section 34, we are taking up the section there.
No. While hearing
No, a
this appeal,
competent court held, you said, against that Supreme Court. Which court? I mean,
our court, my lord,
under which provision? I mean,
when they put the document into my lord
the
execution.
executing court said
Yes,
that.
the executing court said. Executing court refused my lord execution, dismissed it, saying that it's not an award.
Right.
So that order is today, as on date, my lord, is staring. That is why, my lord, in my respectful submission, they have to, my lord, choose. If, my lord, they say that, my lord, this is an award, then, my lord, in my respectful submission, my lord, they cannot do that in view of the pendency of the matter before the Supreme Court in any event, in view of the subsistence of the order passed by the executing court.
But that order is in jeopardy in the sense that Justice SBC's judgment in that Section 5. In jeopardy in the sense that an SLP is pending.
Yes.
And so their stand remains the same, that it's a
Yes.
concluded award.
Yes.
So therefore, they are taking the same stand here.
Very well.
no.
What no? Who is Mr. Bhattacharya appearing for?
Oh, sorry, I'm assisting Mr. Mitro.
Assistant whispers, Mr. Bhattacharya.
I'm sorry. I'm
Using
sorry.
the microphone, please. You're disturbed even. Taken. Visibly. No, but Mr. Mitro, you understand, yes. So they have to elect, that is your.
They have to elect. Now, my lord, on the one hand, my lord, they cannot say that no. Kindly look into our. Kindly come to the, my lord, Section 9 application once, please. Kindly come to, sorry, it's most of it, my lord, so far as at least my brief is concerned, illegible, but I will try to assist your lordships.
You would be relying on certain paragraphs of the section.
Yes.
No, our brief is
Very well.
legible. Yes. If this
Well,
is
kindly come to paragraph 6 at page 58.
yes.
The proceeding in question where conciliation.
Conciliation stroke mediation.
Conciliation. Yes. Conciliation/mediation proceeding commenced at the instance of both the groups, which ultimately resulted in a settlement agreement dated 10 September 2024 having the force of an award. Arbitral award. In the facts and circumstances as truly and correctly stated therein, the petitioner sought execution of the said settlement agreement as an award. In EC number such and such. A copy of the tabular statement is. Then paragraph 7, EC Com 69 was however dismissed by this honorable court by a judgment and order dated 20th May 2025, essentially holding that in view of clause 50 of the settlement agreement containing a provision for arbitration, the same could not be held to be an award and cannot be executed as such. Then, my lord, kindly come to the next page. As will appear from the said application, annexed as Annexure C here too, in the same petition, Sorry, in the same, the petitioner inter alia specifically voiced their concern with regard to the attempts of the respondent to destroy the petitioner's business with two entities, namely so and so, which formed part of the settlement agreement. Then, my lord, it goes on to state about, my lord, the businesses. Then kindly come to page 62.
Yes.
Subsequent to the passing of the order dated such and such, impugned in such and such, EPI group has, without transferring the land in question to ASA group, this transfer can take place only if it is an award, otherwise not. Threatened to prevent ASA group from using the tanks that were being used and are being continued to be used for the purpose of storing the petroleum products and spirits of total and super spirit. Again, my lord, subject matter of the award. This will be evident from the communication exchange. In the course of hearing of the application filed by the petitioners in APOT, counsel appearing for the respondents had undertaken before the Honorable Court that no precipitative action would be taken until the hearing of the appeal. That was the appeal, my lord, preferred from the execution order. Then 12, despite the express undertaking provided by the respondent before the division bench, the respondents have, however, acted and are continuing to act in blatant disregard of the same, as will appear from such and such. Then, my lord, 14. Kindly come to paragraph 14. Apart from being in breach of the undertaking given to the division bench of this honorable court on such and such conduct of the respondent is in complete breach of the terms of settlement agreement, which according to the petitioner has now matured into an award. Without prejudice to such contention, the petitioner says that even assuming without admitting that the memorandum of settlement has not assumed the character of an award, the same still remains a binding agreement between the petitioner and the respondents. The terms whereof the respondent cannot seek to resile from at their own sweet will, which, however, the respondents are clearly attempt to resile from. This is, my lord, the portion which they have spoken about, my lord, the agreement. In my section 11, when I go before the section 11 court by making an application, my lord, they go and say that no, affidavit is required to be filed because it's not an agreement. Now, this is a position, my lord, in my full submission. They have to first, my lord, elect, my lord, whether this is, my lord, a pre-award section 9 or post-award section 9.
Mr. Shah has put his case a bit above that, in the sense, Mr. Mitra,
Yes.
that either way, section 9 would be applicable. Because the question is, this becomes important, whether it's an award or not.
Yes.
Because you are saying that it affects the maintainability of the section 9. So, but if it does not, either way, if Mr. Shah can establish that even if it is an award or if it is not an award, if it is not an award, definitely it's a settlement agreement. They take a stand that it's a settlement agreement, and then section 9 would be applicable. But even if they take a stand that award, it's an award, concluded award, even then section 9 would be applicable. So we are bothered not with their stand regarding award or not. So even if they take a stand that it's an award, he argues that even then section 9 is maintainable. So their taking a stand is not material for that purpose.
In my full submission, my lord, today your lordships, my lord, have to come to a conclusion that whether, my lord, there is an award or not.
No, we are with respect to what you were saying, Mr. Mitra,
Yes.
I could not make myself clear actually. Even if you don't come to that conclusion,
Yes.
suppose we don't come conclusively hold either whether it's an award or not, but we consider the implications on section 9 applicability, either if it's an award or not, we can very well say that if it's an award, in any event section 9 is applicable. If it's not an award, but even if it's an award, then also section 9 is applicable. So that we don't have to decide here whether it's an award or not. If we say that, irrespective of whether it's an award or not, section 9 is maintainable. If we hold that, then, Mr. Mitra, we are not required to adjudicate on that. There are 3 stages, as was being pointed. three stages in the sense. First is we have to see whether the section 9 is maintainable if it's an award as per their stand. If you hold that yes, still it's maintainable, then you did not go into this question, because otherwise it would definitely be applicable.
Very well. Now, my lord, in my full submission, my lord, a defense can be, my lord, contradictory.
Alternative defenses can be made.
Defense can be alternative. Not, my lord, the offense. Their basis, my lord, they have to say. They cannot, my lord, sell on the, my lord, two boards.
But they are saying it's an award consistently throughout the section 9. It's an award. But they make an alternative case in the sense that even if it was ultimately constituted not to be an award, then in any event, section 9 is applicable. So if it's an award, they have a worse case. They have a worse case. Because then this question of 36, it is enforced, that comes in. But if it's not an award, in any event, section 9 would be applicable.
And it is my learned friend's case that it is not an
It's a case, it's not an award. So in any event, it would be applicable.
No, it's not the question of my case, my lord. In my full submission,
That's why we did not say that.
Yes.
We did not say that. We did not go that far. It has to be determined on their case. Their case is that it's an award. We need not decide. If you decide that even if it's an award,
Yes.
then section 9 is maintainable. Then this question need not be gone into at
My
all.
lord, if they say, my lord, this is an award, now, my lord, which is under challenge? Now, my lord, can this court, my lord, pass an order, if I may ask myself?
Can the section 9 court?
Yes.
Why not? Please explain that.
If they say it is an award, they are proceeding on the basis that it is an award. And
Their case is then also it can be passed, and that is what you are arguing on the last one. Section 36, the language of section 9, it is enforced whether it means final enforcement or putting into enforcement. That is what you are arguing on the last one.
my lord, so the doctrine of election will not come into force here.
This is not a final opinion. We are just opening up our mind.
I was wondering, my lord. I was wondering.
May not be relevant for this purpose, for deciding the maintainability of the section 9. That is what we are saying. Because we can take their worst case, and if we find that on their worst case also section 9 is maintainable, then doctrine of election becomes irrelevant, academic. In the enforcement proceeding, that's the issue. It's not academic. That has to be decided. But in a section 9, if we hold that it's an award, even if it's an award, then section 9 is maintainable. Then they win on the worst case. These are all prima facie. In section 9, in any event, it's prima facie. It's not a final adjudication.
My lord, only I was wondering, my lord, while deciding our hearing and section 9 application, the court is required to look into the basis of that.
Court did look into that. That's why they're before us. That's the difficulty.
Yes.
Ideally, it should not. But prima facie, it should. Because the point is taken by you. And a valid point, very valid argument. That whether, whether it's an award or not. If it's an award, whether by virtue of the enforcement having already been levied, whether section 9 is maintainable at all. Even on their case, you have made your arguments.
Maybe it is no. I don't think so. Copy May I, my lord, in that event, may I rely on,
please, absolutely.
A division being judgment of my lord the Madras High Court.
Yes. Yes.
Kindly come to my lord paragraph. It's a short judgment, my lord. Kindly come to paragraph 5.
Yes, sir.
In short, notwithstanding the Act of 1996 being a complete code and governing everything pertaining to arbitration, once an arbitral award in full or part becomes enforceable, the enforcement of such award or part of the award has to be in accordance with the code. In a manner of speaking, the matter as to the enforcement of the award slips out of the purview of the Act of 1996 and falls within the domain of the court for it to be exclusively governed by the court thereupon. Though such aspect of the matter may not be relevant in the present context, but for the completeness of the discussion on the aspect, it must not be lost sight of the word court in the relevant expression in section 36(1) of the Act is preceded by the definite article. That would necessarily imply uh, that the court before execution of an arbitral award is sought must have been capable to entertain a suit between the parties in respect of the subject matter of the arbitral reference. The choice of the definite article instead of indefinite necessitates such construction and excludes any other. However, wide the powers conferred on a court under Section 9 of the Act may be seen to be. Such powers may not extend to issuing orders for discovering the assets of an award debtor. Order 21 of the Code that provides for execution carries the necessary provision for such purpose, and Section 9 of the Act cannot be enlarged to incorporate the wide authority that an executing court has to aid the award holder, whose metamorphosis as a decree holder by the legal fiction contained in section 36(1) of the Act to seek to obtain orders of such nature, or of arrest or detention of the award debtor or the sequestration of the assets of the properties. The quality of the orders that can be passed under section 9 of the Act are substantially different from the quality of the orders that may be passed in the course of execution, while the emphasis in section 9 is to be the subject matter of the arbitration and may even charitably be seen to be cover the subject matter of the award. Orders in the nature of discovering assets of the deemed judgment debtor or requiring him to file an affidavit of asset and the like may not be seen within the ambit of the authority available under section 9. The Act of 1996 covers all things pertaining to arbitration and operates between the commencement of the arbitral proceeding within the meaning of section 21 and conclusion of matters pertaining to the arbitration and before section 36 kicks in so as to say and renders the award enforceable.
This is an answer to our question also to put to Mr. Dotto that section 9 is wider than 36. Then the only remedy would be 36(2). This provides an answer to that also. Under Order 21, court can do that, the executing court.
Yes. Now, my lord, Order 21, as I submitted before your lordships, that, my lord, as soon as, my lord, Order 21 execution is filed, my lord, that encompasses everything. Now, my lord, enforcement, my lord, if the question of, my lord, enforced comes in, my lord, in my respectful submission, nothing remains to be done. When it is enforced, my lord, nothing remains to be done.
And by enforced, you mean putting it into enforcement?
By
being execution.
Enforcement, my lord, yes. Putting into execution. The orders which has been sought for, my lord, if I may ask myself the question, can it not be prayed for, my lord, in my lord execution? If it was an award. Those were the prayers there also. Maybe in different form. Maybe in different form.
You mean to say that under Order 21 itself it could be done?
Absolutely. Now, my lord, Lordship, my lord, knows, my lord, in execution, my lord, we ask for everything. For interim protection also. If interim protections, my lord, can be asked for, my lord, in execution, my lord, in my full submission, the prayers made could have been given, my lord, in the execution also, my lord. That is not required, my lord. My lord, the language used, my lord, in my full submission cannot be said to, my lord, till it is finally enforced. It is enforced, my lord, in my full submission means, my lord, when it is put to execution. Those are my submissions.
But as your lordship has pointed out, there are two expressions used. One in section 36, it says shall be enforced after the expiration of the period of challenge. Shall be enforced means after the period of challenge expires, I can put it in the process of enforcement. But the difference, in the expression in section 9 is, it says before it is enforced. Now, that is the essential difference. Now, the peculiarity of the situation is, today, I may put the award in enforcement. If it is enforceable as an award, in that case, of course, the process of section 36 and then section order 21 will take over. But where a person comes and said it is not an award, and ultimately the executing court has held that, in my opinion, it has not matured into an award because of the presence of an arbitration clause. It has not attained finality. Then, my lord, is it still, enforceable? Because, my lord, a judicial order is now, present on record which says it is not enforceable. My lord, when there is an order of a high court, my lord, which says it is not enforceable, my lord, then, my lord, whether this, my lord, the play of words, in section 9 and section 36 will at all, come into effect. Because,
but then you would be guilty of taking a dual standard. As
no, my stand is very clear. My stand is consistent. I say it is an award. Unfortunately, I have suffered an order where a court has held that no, we find it is not an award. Now, where the court finds it is not an award, in that case, section 36 will not come to my aid. I will not be able to, even put it up for enforcement. So, my application has been rejected. My execution application on date stands rejected, which means that the court has said that the award is not enforceable. Now, if the award is not enforceable, I am within my rights to pursue my rights up to the Supreme Court on this aspect. But the question is whether the law then contemplates a vacuum in a situation like this, where my rights, although I have rights, will be in suspension until the Supreme Court decides the matter. You can transgress upon my rights, trespass upon my rights, cause me whatever prejudice you want.
The principle of ubi just, ibi remedium.
Yes. Your lordship was pleased to point it out in the first day. There can be no wrong without a remedy. Now, so far as that is concerned, this is the first answer on facts. The second answer on law is, my lord, here we did not really travel to that distance because, the court has held it is not an award, it's not enforceable. So, the question of 36, 34 and 9 does not come in. But, what is more important here is, the question of law. Now, my learned friend has relied on the Madras High Court judgment, the division bench of Madras High Court. Unfortunately, the Madras High Court has, proceeded without, making a clear, exposition of what would be the meaning of the expression, before it is enforced. The only words, which have been used really after, discussing, whatever has been discussed, the only expression is, it says, the paragraph 9, the 1996 Act covers all things pertaining to arbitration and operates between the commencement of the arbitral proceedings within the meaning of section 21 of the Act of 1996 and the conclusion of matters pertaining to arbitration before 36 kicks in. Now, when 36 kicks in, it says it shall be enforced. But well, if it is not enforced, well, what happens? Well, that was the question that had fallen for consideration in other judgments. Now, well, here, may I draw your lordship's attention to a judgment of the Supreme Court in the case of Hindustan Construction.
You had cited it on the
No,
previous
well, I
one.
have not cited. Well, because Mr. Mittal cites this Madras High Court judgment, that is why I'm showing your lordship.
Mr. Mittal will get a reply on this because it's in the context of your matter.
Yes, yes, of course. But my lord, now, my lord, this, my lord, if your lordship will kindly have a look at paragraphs 35 to 37. My lord, this is 2020, volume 17, Supreme Court cases 3 to 4. Well, this is the discussion. Well, first on 34, well, it refers to section 36, paragraph 34. Well, I'll read from paragraph 34. To read section 36 as inferring something negative, namely, that where the time for making an application under section 34 has not expired, and therefore, on such application being made within time, an automatic stay ensues, is to read something into section 36 which is not there at all. Also, this construction omits to consider the rest of section 36, which deals with applications under section 34 that have been dismissed, which leads to an award being final and binding when read with section 35 of the Act of 1996, which then becomes enforceable under the CPC, the award being treated as a decree for this purpose. This also finds support from the language of section 9 of the Arbitration Act of 1996, which specifically enables a party to apply to a court for reliefs after the making of the arbitration award, but before it is enforced in accordance with section 36. The decisions in NALCO and FISA developers overlook this statutory position. These words in section 9 have not undergone any change by reason of the 2015 or 2019 Amendment Acts. Interpreting section 9 of the Arbitration Act 1996, a division bench of the Bombay High Court in Dirk India Limited held as follows. The second facet of section 9 is the proximate nexus between the orders that are sought and the arbitral proceedings. When an interim measure of protection is sought before or during arbitral proceedings, such a measure is a step in aid to fruition of the arbitral proceedings. When sought after an arbitral award is made but before it is enforced, the measure of protection is intended to safeguard the fruit of the proceedings until the eventual enforcement of the award. Here again, the measure of protection is a step in aid of enforcement. It is intended to ensure that enforcement of the award results in a realizable claim and that the award is not rendered illusory by dealings that would put the subject of the award beyond the pale of enforcement. This being the legislative intent, the observation in NALCO that once a Section 34 application is filed, there is no discretion left with the court to pass any interlocutory order in regard to the said award flies in the face of the opening words of Section 9 of the Arbitration Act of 1996 extracted above. Now, my lord, this is, my lord, what the Supreme Court had held. My lord, ultimately, the object is to protect the fruits of the award till, my lord, it is enforced. Now, my lord, as my learned friend says that, yes, it is possible perhaps, although, my lord, this is not the specific, my lord, provision in Order 21. It is possible perhaps to also say that pending, my lord, at realization of monies lying in a bank account, to attach the bank account in Order 21, my lord, which we do in execution cases. My lord, the question is therefore, my lord, today, my lord, if today this, my lord, is available to me as an award, if, my lord, no one contests this position, it might still be possible. But the Supreme Court has said that the legislative intent is, my lord, that it is not, as if there is no discretion left with the courts at this juncture. Now, my lord, so far as this matter is concerned, this, as your lordship has seen, has relied on the judgment of Dirk India Limited in Bombay, my lord, which has also said before it is enforced.
Dirk India is clear on that.
Yes, clear.
Whatever fell from us initially, which is contrary to the Madras High Court.
Yes, and my lord, Dirk India has been followed by the Supreme Court.
This being the legislative intent,
yes,
referring to Dirk.
Yes, because my lord, paragraph 9 is Dirk, and well, paragraph 36 is 4 is Dirk, and 35 is thing. Now, my lord, so far as the Madras High Court is concerned, the Madras High Court also, my lord, had doubts about, my lord, the division bench judgment. Two judges, my lord, have similarly expressed the doubt. And finally, the matter has been referred to a larger bench. It is now pending before a larger bench. My lord, those judgments, my lord, I'll just show your lordship.
Expressed doubt on this?
Yes.
Gopuram?
Yes, yes. Gopuram has been, my lord, doubted. It's taken by surprise. হ্যাঁ দেখো প্যারাগ্রাফটা বলে দাও আমার একটু ডাউট হচ্ছিল বিদ্যা বলে কিছু বলতে পারছি
Thank God this division bench was sitting in Madras. The one you cite. Probably one of us would get a tight slap also.
Yes. In this judgment, Madras High Court, of course, single judge. Please see paragraphs 12, 15, and 16. Kindly see paragraph 12. Dirk is referred to. Dirk India Private Limited.
Yes.
Then, your lordship will see paragraph 15. Hindustan Construction is referred to. And paragraph 16. Therefore, the very purpose of providing interim relief after passing of the award, but before the enforcement of the arbitral award, is to secure its value for the benefit of the party who seeks enforcement of the award. Thus, after the award is made, the remedy under Section 9 is only a step in aid of enforcement of the arbitral award until the complete satisfaction of the award or eventual enforcement of the award. In other words, until complete satisfaction of the award, the protection under Section 9 is very much available to the award holder. Otherwise, the award becomes elusive. And your lordship will see in paragraph 17, then of course, there's further discussion. Then please see references made to Gopuram. And Gopuram is extracted. Then paragraph 19. On going through the judgment rendered by the division bench of this court, I find that the Honorable Division Bench of this court has not considered the law laid down by the Honorable Apex Court in Hindustan Construction Company, cited supra, wherein the judgment of the Bombay Division Bench in Dirk India was approved, cited and approved. In the said judgment of the Bombay High Court, it was held that where an interim measure of protection is sought before or during arbitral proceedings, such a measure is a step in aid to the fruition of the arbitral proceedings. When sought after the arbitral award is made but before its enforcement, the measure of protection is intended to safeguard the fruit of the proceedings until the eventual enforcement of the award. Therefore, it was held that the interim measure of protection is a step in aid of enforcement and intended to ensure that the enforcement of the award results in a realizable claim and that the award is not rendered illusory by dealings that would put the subject of the award beyond the pale of enforcement. These aspects were not considered by the Honorable First Bench of this court in Gopuram case, even though the judgment of the first bench was subsequent to the judgment of the Honorable Supreme Court in Hindustan Construction Company case. Therefore, this court is inclined to apply the ratio laid down by the Honorable Division Bench of the Bombay High Court in Dirk India Private Limited case, which was subsequently approved by the Apex Court.
This was a single judge.
Yes. And then, thereafter, there is another judgment of the Madras High Court. This is in BM insulation. 4, 5 to 8. Please have a look at paragraph 3 onwards. This is also a land single judge. Paragraph 3. When the matter was taken up for hearing today, the learned counsel for the applicant brought to the notice of this court. 3.
Oh, sorry. There is a double 3 actually.
Oh,
anyway, the first 3.
Yes, first 3. When the matter was taken up for hearing today, the learned counsel for the applicant brought to the notice of this court the judgment of the division bench in the case of Gopuram Enterprises Limited. Then the relevant portions are once again extracted.
Oh no, this was 3 of that Gopuram.
Yes, that's the extracted 3.
The quotation mark has not been ended anyway.
Yes, ma'am.
Whatever. Yes.
Then your lordship will see paragraph 4.
Yes.
This is the judgment of Justice Krishnan Ramaswamy.
The one
that is extracted. Then your lordship will see paragraph. It's a paragraph 19.
Could have been put in smaller font or italics. That
yes, I think this.
5 is at.
Yes, 5 is at.
We have found 5.
Yes. The council relies on the division bench judgment in OSS such and such, which was an appeal filed against the order dated such and such. The relevant portions are extracted. Primordial contention of the appellant is that the learned single judge has not discussed on merits of the contention, and the whole discussion was about the maintainability of an application under Section 9 of the Arbitration and Conciliation Act 1996. After coming to the conclusion that the application under Section 9 of the Act is maintainable, learned single judge straightaway made the interim stay absolute. According to the appellant, the web series is not yet completed. The learned senior advocate of the appellant submits, etc. Well, this is perhaps not relevant.
This was the division bench. The challenge against Justice Ramaswamy.
Yes. Yes.
Then this was the division bench.
Yes.
Which is being quoted.
Well, please see paragraph internal paragraph 6. It appears that while passing the impugned order, learned single judge only debated upon the maintainability of the petition under Section 9, and after arriving at the conclusion that the petition under Section 9 is maintainable, straightaway made the interim order stay absolute. No reasons, here, of course,
on that ground,
as the order stands reasons, that matter was demanded back. Then, please see 6 and 7. Counsel for the applicant submitted that the plain reading of Section 9 of the Act makes it clear that a party can seek interim measures under Section 9 even post the arbitral award before it is enforced. The learned counsel submitted that the division bench in the case of Gopuram Enterprises cited supra read the word enforced as enforceable. Paragraph 6 page 10. Thus, a restricted meaning was assigned to the scope of Section 9, and by virtue of the judgment of the division bench, once the time frame provided under subsection 3 of Section 34 expires, the award becomes enforceable, and therefore Section 9 application cannot be maintained before this court. This restricted meaning assigned by the division bench was considered by the learned single judge in OSN such and such, and the learned single judge has taken note of the judgment of the Bombay High Court in the case of Dirk India Private Limited, a report in such and such, which in turn was taken note of by the Honorable Apex Court in Hindustan Construction Company, to conclude that the application under Section 9 of the Act will be maintainable till the award is enforced under Section 36 of the Act. Order passed by the learned single judge was interfered by the division bench only on the ground that the learned single judge did not deal with the matter on merits, and hence the matter was remanded back to the learned single judge to deal with it on merits. Thus, the finding of the learned single judge to the effect that an application under Section 9 of the Act can be maintained post-award till the award is enforced has been upheld by the division bench. Therefore, it is contended that there are two divergent views taken by the two division benches of this court. In the considered view of this court, clarity is required to understand the scope of the word enforced used in Section 9. Since there are divergent views expressed, it will be more appropriate to refer the issue to a full bench. But, my lord, what? So, my lord, two different Madras High Court judgments of the division bench. My lord, learned single judge, my lord, relies on Bombay High Court and Supreme Court. And, my lord, that is where the matter is. But, my lord, with the greatest of respect, perhaps, my lord, this issue is academic in our case. Because, my lord, in our case, my lord, the learned judge has said, my lord, in execution, I will not admit the application, pass orders in execution, including, my lord, injunctive reliefs, because I do not find it is enforceable. Although, my lord, today enforceable must be read as till it is enforced. That is the language of Section 9. And, my lord, we cannot, my lord, do violence to the language of the statute, particularly, my lord, since there are different expressions used in 36 and 30 and Section 9. And very deliberately so. Shall be put in force. Because, my lord, again, just, my lord, to take your lordship 1 minute of your lordships, Section 36 said it shall be enforced, which means you shall put it in the process of enforcement. Order 21 does not, my lord, contemplate in itself any injunctive relief or any interim measure. Had, my lord, that been the situation, perhaps it may have been a different case. My lord, what we do by way of convention or practice is, my lord, something else. But Order 21, my lord, in its various, my lord, rules, does not contemplate the passing of an interim measure of protection. Section 9 is for an interim measure of protection. And that is why the clear, my lord, difference in the expression used, my lord, in Section, my lord, 36, which says shall be enforced, and, my lord, before it is enforced. My lord, on the merits of the matter, my lord, I have made my submissions. I have shown you, lordship, the clauses of the agreement or award, whichever way we look at, which clearly says that these businesses will come to me. You cannot interfere with the rights of those businesses. My lord, to that, my lord, there is no answer. My learned friend has, my lord, argued on the merits. My lord, I think, my lord, this is all that we need to, my lord, argue with your lordships.
So we will hear you on these judgments after taking a short break. Yes.
The first decision, my lord, relied on of Supreme Court.
Hindustan. Hindustan first.
Hindustan. Now kindly come to the paragraphs, my lord. Paragraph 34. To read section 36 as inferring something negative, namely that where the time for
This is paragraph 34 of
Hindustan, my lord.
Oh, Hindustan. Say, acha, right. Yes, Mr. To read.
To read section 36 as inferring something negative, namely that where the time for making an application under section 34 has not expired, and therefore on such application being made within time, an automatic stay ensues, is to read something into section 36 which is not there at all. The issue was different. Also, this construction omits to consider the rest of section 36 which deals with application under section 34 that have been dismissed, which leads to an award being final and binding when read with section 35 of the Arbitration Act, which then becomes enforceable under the CPC. The award being treated as a decree for this purpose. This also finds support from the language of section 9 of the Arbitration Act, which specifically enables a party to apply to a court for reliefs after the making of the arbitration award, but before it is enforced in accordance with section 36. The decision in NALCO overlooks the statutory provision. These words in section 9 have not undergone any change. Then, my lord, interpreting section 9 of the Arbitration Act, a division bench of the Bombay High Court in Dark has held this. This second, I have placed this, may I place it once again, my lord. The second facet of section 9 is the proximate nexus between the orders that are sought and the arbitral proceedings. When an interim measure of protection is sought before or during arbitral proceedings, such a measure is a step in aid of the fruition of the arbitral proceeding. When sought after an arbitral award, is made, but before it is enforced, the measure of protection is intended to safeguard the fruit of proceedings until the eventual enforcement of the award. So, it says until the eventual enforcement of the award. Protection for that purpose. Here again, the measures of protection is a step in aid of enforcement. It is intended to ensure that enforcement of the award results in a realizable claim and that the award is not rendered illusory by dealing with what would put the subject of the award beyond the pale of enforcement. This being the legislative intent, the observation in NALCO that once a section 34 application is filed, there is no discretion left with the court to pass any interlocutory order in regard to the said award flies in the face of the opening words of section 9 of the Arbitration Act 1996. But that was the issue. Well,
It was different.
Now, the other two decisions, Krishna Ramashami. Krishna.
15, 16.
My lord, the next one is, my lord, a judgment of, my lord, a single judge of Madras High Court, my lord, in OA number 284 of 2023. Paragraph 12, they have relied on. In the case of Dark, the Bombay High Court has held in paragraph such and such. Then 13. In the above referred judgment, the Bombay High Court has categorically held that when a relief is sought under section 9 after an arbitral award is made, but before it is enforced, the measure of protection is intended to safeguard the fruit of the proceedings until the eventual enforcement of the award. It has further held that the measure of protection is a step in aid of enforcement, and it is intended to ensure that enforcement of the award results in a realizable claim and that the award is not rendered illusory. Therefore, on going through the above judgment of the Bombay High Court and Section 9 read with Section 36, it is crystal clear that the interim protection of the award is available under Section 9 and it is intended to safeguard the fruit of the proceeding until the eventual enforcement. Yes, definitely. Section 9, my lord, if my lord an application is made after the award but before it is enforced, that order continues. It does not end, my lord, on filing of the enforcement.
He could also submit.
In para 16, this eventual enforcement has been read as complete satisfaction
Paragraph 60, may I, my lord?
of Justice Ramaswamy.
May I read it again, my lord? Therefore, the very purpose of providing interim relief after the passing of the award, but before the enforcement of the arbitral award, is to secure its value for the benefit of the party who seeks the enforcement of the award. Thus, after the award is made, the remedy under Section 9 is only a step in aid of enforcement. Step in aid of enforcement of the arbitral award until the complete satisfaction of the award of eventual enforcement of the award.
So complete satisfaction or eventual enforcement, both have been equated by this bench. Complete satisfaction can only mean the end of the section.
That's true.
This is the interpretation of this learned single judge, which may or may not be correct. I mean, we are not going to.
Is only in aid of enforcement of the arbitral award.
The term eventual enforcement has been read as complete satisfaction. The eventuality step in aid until the complete satisfaction of the award.
Yes.
Which has to be the
Step
end.
in aid of enforcement until the complete side. Yes, because the order continues.
Complete satisfaction of the award can only be when the section 36 is culminated.
Sorry, my lord, I possibly could not make myself clear. What I'm trying to say is, my lord, yes, Section 9 order is passed. After that, my lord, execution is filed. And the order of Section 9 continues till it is finally enforced. Till the award is finally enforced.
So then there is a period when there is coextensive applicability of order Section 9 and Section 36. If an order is passed before, then it continues till the satisfaction of the award, you are saying.
Yes, because, my lord, if an order is passed, my lord, it does not end there. It continues. It's nothing, my lord, it's not, my lord, like an award is made. Section 9, my lord, pre-award, my lord, or pre-award Section 9 order continues till the award is made. Similarly, my lord, in my full submission, in case of post-award Section 9, the order continues till, my lord, it is finally executed. Now, if it is now this, yes, the next one was, my lord, is dated 1st September 2025, another single judge of Madras High Court, my lord. In arbitration application number 374, paragraph 3 kindly come to. There, page 3. Oh no, page 9. Sorry. Paragraph 3.
Yes.
When the matter was taken up for hearing today, the learned counsel for applicant brought to the notice of the court the judgment of the division bench in Gopuram. The relevant portions are set out. Then kindly come to paragraph 4. The learned counsel for applicant relied upon the order passed by Honorable Justice so-and-so in way number such and such dated 28th April 2023. The council relied upon the following portions of the order. Then, my lord, kindly come to paragraph 6. The counsel for applicant submitted that a plain reading of section 9 of the Act makes it clear that a party can seek for interim measure under section 9 even post the arbitral award before it is enforced. The learned counsel submitted that the division bench in the case of Gopuram cited supra read the word enforced as enforceable. Thus, a restricted meaning was assigned to the scope of section 9, and by virtue of the judgment of the division bench, once the time frame provided under section 3 of section 34 expires, the award becomes enforceable, and therefore section 9 application cannot be maintained before this court. This restricted meaning assigned by the division bench was considered by a learned single judge, and the learned single judge has taken the judgment so and so, etc. Now, my lord, interestingly, yes, it was placed before, it has been placed before a full bench, but interestingly, my lord, the same learned judge has passed an order subsequently. My lord, on 30th October 2025, an order has been passed by the same learned single judge.
Mr. Shah, you will have an answer to this, but this is the last order of this judge we are seeing. This, of either of the two judges, Justice Ramaswamy or this. You get to answer this, but this will be the last subsequent judgment.
I leave it to your lordship, but I need not venture any further answer.
My lord, kindly come to paragraph 20. Yes. Got it, my lord. Page 9, page 8 at the top. In the decision in Gopuram, the first bench of this court held that once the arbitral award becomes enforceable, the enforcement of such award has to be in accordance with the Civil Procedure Code, that the Act will cover all things pertaining to arbitration and operates between the commencement of the arbitral proceeding within the meaning of section 21 of the Act, and that its operation concludes once it reaches the stage of section 36. That stage has reached once the award ripens for implementation, and at that stage an application under section 9 of the Act cannot be maintained. The said judgment of the first court was taken into etc. Kindly come to paragraph 27 thereafter, my lord.
This is 3 judges.
Oh.
This is what the last judgment said.
Yes.
Dark in the sun construction. Summarize.
Kindly give me a minute's time.
Yes, please.
Dark.
Dark in the sun construction is the correct one. Enforcement. Let us enforce here.
এটা কি ছিল এগুলো? Kindly don't look into. Don't look into this.
Against you?
No, no. The full bench judgment has come.
Oh. Of the matter side.
Yes, it's 21st January 2026.
Do you get it in SCC online?
No, no.
What has been held? In your favor?
No. No. I should point it out.
No, no. Mr. Mitru, that much we should not say that even.
The correct position of law has been laid down in dark, cited supra, which has also been approved by the Honorable Supreme Court in Hindustan. Cited supra, in the light of the same, the stance taken by the division bench of the court in Gopuram, supra, by reading down the word enforced as enforceable, is held to be bad in law.
So we'll have to consider whether we'll follow the Madras full bench or the other. But what is the composition of that bench? We are interested.
3 judges.
No,
I see.
the name
I
of
see, yes.
we are interested. I am interested in these
Just
tidbits more than
the other. May.
Can you just supply printouts of from it?
But again, my lord, my case is not when it becomes enforceable. My case is when it is put into execution.
Yes.
It is enforced. My lord, in this context, my lord, kindly once take up, my lord, the Civil Procedure Code.
Only attachment.
Yes.
Kindly come to, my lord, Order 21, Rule 31.
31, yes.
Where the decree is for any specific movable or for any share in a specific movable, it may be executed by the seizure, if practicable, of the immovable or share, and by the delivery thereof to the party to whom it has been adjudged, or to such person as he appoints to receive delivery on his behalf, or by the detention in the civil prison of the judgment debtor, or by the attachment of his property, or by both, can be executed by attachment of his property or by both. My lord, that is not, my lord, the final execution. It's not finally executed. The word, my lord, executed, used by the legislature in Civil Procedure Code, my lord, also contemplates, my lord, interim orders. That would appear from, my lord, Sub-Rule 2, where any attachment under Sub-Rule 1 has remained in force for 3 months if the judgment debtor has not obeyed the decree and the decree holder has applied to have the attached property sold. Such property may be sold, and out of the proceeds the court may award to the decree holder, in case where any amount has been fixed by the decree to be paid as an alternative to delivery of immovable property, such amount, and in other cases such compensation as it thinks fit and shall pay the balance, if any, to the judgment debtor on his application.
But this is a step in execution, final execution. There is no interim
My lord,
order.
the word executed, what I'm trying to submit before your lordships, that, my lord, the word executed does not mean, my lord, it is finally executed. It is put to execution. That is what I am trying to submit before your lordships. My lord, those are my respectful submissions. My lord, troubled your lordships for long.
Close arguments. Would you like to put in written notes of arguments, because we might miss some points are very limited. We have taken our notes, but we are apprehending that we may miss out on some of these.
Well, I'll file it, my lord, by
How soon can I file?
by Monday.
Wednesday.
Oh, we take up these matters only on Wednesday.
But I can file it by next.
So you can file it with our officers. I mean, you can just have it.
Very good. Can file it on Monday.
Mr. Mitra, how soon can you file it, or should we put it on Wednesday?
Wednesday.
We'll put it on Wednesday. Not difficult. Hearing is oral arguments are concluded. Push up. Then senior counsel appearing for the parties are requested to file written notes of arguments. File their respective written notes of arguments on February 11, 2026, when the matter shall be listed under the heading to be mentioned for such purpose. Thank you.
During recess, we shall provide that judgment.
Yes, please. Yes. একটা জাজমেন্ট আপনি দিয়ে যাবেন, ওটা এর সঙ্গে রেখে দিতে, ওটার উপরে একটুখানি
তো বলা হয়ে গেছে।
5 and 6, I beg. 5 and 6, I beg to appear for the complainant, my lord. We have begin with our argument. Mr. Kaur is leading me, my lord. He's already on his. Let me start. Like he can join, man.
fair enough.
But on the last occasion, Mr. Kaur was showing, my lord, was the regulation. How the whole procedure.
You are answering them, right?
My lord, we are answering as well as re-arguing, like also placing our case.
Oh, yes.
Yes, my lord.
Yes.
My lord, Mr. Kaur was showing your lordship about the regulation and how the procedure in disciplinary committee as well as in the council is being done, my lord. With regard to my lord, I will beseech your lordship to take up the regulation once, my lord.
Not copy it.
12 I mean,
Regulation.
I've been led by Mr. Chakraborty as well, my lord.
Mr. Kaur was showing your lordship regulation 12, lord. বাড়ি চলে যা,
এইরকম সাইজ হবে, এইরকম মাঝারি সাইজ। ওই
রেগুলেশনটা দেওয়া হয়েছিল,
মোটাটার নিচে যেটা রয়েছে, পুরো মোটাটা পেপার বুকটার নিচে সাইজ। অন্য ম্যাটার শিওর টু অন্য ম্যাটার, এটা কিন্তু একই জিনিস লেখা, অ্যাক্টস এন্ড রেগুলেশনস। এখানে আমাদের অ্যাক্টস এন্ড রেগুলেশনস লেখা।
হ্যাঁ হ্যাঁ ঠিক আছে, জল আনে
না। I'm taking 2 minutes, Lord, if you're not.
Yes, yes, that's whatever.
I climbed up the stairs, so I thought.
Oh, you can. Sorry. Yes. Regulation 12, page 10 আছে। তলায় page.
Mr. Mitro has made an argument that the institute or the disciplinary committee ought not to have called us, the complainants, during the course of inquiry. I will kindly have a look at regulation 12. I think that regulation itself has an answer, in my humble understanding, Lord. Subject to the provisions of this regulation, a complaint against a member under section 21 shall be investigated and all other inquiries relating to misconduct of such member shall be held by the disciplinary committee, provided that if subject matter of the complaint is, in the opinion of the President, substantially the same as or has been covered by any previous complaint or information received, the Secretary shall file the said complaint without any further action and inform the complainant accordingly. So this is the first step. If they found that it is earlier or similar, they will drop it here and then. 2. A complaint under section 21 shall be in the appropriate form duly verified. Then 3. Such complaint shall contain the following, my lord: act and omission which is, if proved, would render the person complained against guilty of professional or other misconduct, the oral and other documentary evidence relied upon in support of the allegation. My duty to make that. Then 4. Every complaint other than a complaint made by or on behalf of the central or state government shall be accompanied by a deposit of 100 rupees, which will be forfeited if the council, after considering the complaint, comes to the conclusion that no prima facie case is made out, and moreover that the complaint is either a frivolous one or is made with malafide intention. That's also before calling me. Then 5. Secretary shall return a complaint which is not in the appropriate form or which does not contain the aforesaid particulars to the complainant for representation after removing the objections thereto and within such time. Then 6. Ordinarily within 60 days of receipt of the complaint under section 21, the Secretary shall, kindly mark this, if the complaint is against a member, send a copy thereof to such member at his professional address as entered in the register. Now, let us take a situation that my complaint was up to 5, it complied, that is why it was sent to them. Then B, if the complaint is against a firm, send a copy thereof to the firm at the address of his head office as entered in the register of the office of the firm, with a notice calling upon the firm to disclose the names and members who is answerable to the charge of misconduct and requiring it to send a copy. Then 7, a member against whom the complaint is made, hereinafter referred to as the respondent, may within 14 days of the service of the copy of the complaint under section 6 or within such time as may be extended by the Secretary, forward the Secretary in triplicate a written statement in his defense verified in the same manner. This was done by them. Our complaint was sent to them, they sent their written statement. Then 8, on receipt of the written statement, if any, the Secretary shall send a copy of the complaint, and the complainant may within 14 days of the service of the copy of the written statement or within such time as may be extended by the Secretary, forward to the Secretary in triplicate his rejoinder to the written statement duly verified in the same manner. So it will be forwarded to me, to the complainant, for my rejoinder to the written statement. 9, on receipt of the complainant's rejoinder, if any, the Secretary shall send a copy thereof to the respondent, and the respondent may within 14 days of the service of the copy of the rejoinder within such time as may be extended by the Secretary, forward to the Secretary in triplicate comments to the rejoinder. Complaint WS rejoinder, comments to the rejoinder. Then, on a perusal of the complaint, the written statement, if any, the complainant's rejoinder on the written statement, if any, and the respondent's comment on the complainant's rejoinder, if any, the President may call for the additional particulars or documents connected therewith, either for the complainant, from the complainant or respondent, as the case may be. But till such time, all pleadings are over. Then 11. If on perusal of the complaint, the written statement, if any, complainant's rejoinder to the written statement, if any, and the respondent's comment on the complaint rejoinder, if any, and other relevant document, the council is prima facie of the opinion the respondent is guilty of professional and other misconduct, council shall cause an inquiry to be made in the manner by the disciplinary committee. Now, my lord, this making of inquiry would obviously involve calling upon the complainant.
Don't have a right of hearing. It's their prerogative who they call.
They have done that. They have done. Mr. Mitra's argument was, by this, they ought not to have done that. The council, the disciplinary committee has called us for the purpose of making this inquiry. So there is no illegality or irregularity in the process.
Council shall cause an inquiry.
Yes, while causing that inquiry.
Proceeding committee comes at rule 815.
Yes, my lord, the disciplinary committee, the council is prima facie of the opinion that the respondent is.
Mr. Mitra's point that you did not have any right of hearing before the disciplinary committee.
Yes.
So 15 provides for the procedure. What is your right?
Lord, kindly have a look at 11. Kindly have a look at 11.
11 is all council.
The council, if
Council level, the council will undertake.
council is of the prima facie opinion that the respondent is guilty of,
An inquiry.
to be made by the disciplinary committee. The DC will cause an inquiry, Lord, for the
That
purpose
per
of,
se does not mean that you have a right of hearing.
Lord, whether I'm trying to
You
submit
look into
is,
the papers and
But for the
contact third parties even.
for the purpose of making an inquiry, they could have called me. So there is no,
but no right.
Lord, I am not seeking for a right. It was their submission that this is a or wrong or irregularity.
Hearing was given to you.
But for the purpose of making an inquiry, the disciplinary authority called me. Lord, kindly sees my complaint, his written statement, my rejoinder, his reply. Thereafter, for the purpose of inquiry, the DC called me. Lord, inquiry would obviously involve Lord calling on the complainant and Lord inquiring that about the truth of the complaint and the materials. Yes. And kindly Lord allow me to proceed further. If on the other hand, 2 II, if on the other hand, the council is prima facie of the opinion that the respondent is not guilty of any professional or other misconduct, the complaint shall be filed and the complainant and the respondent shall be informed accordingly. So no further inquiry. If there's a prima facie finding that he is guilty, DC will make an inquiry. Then 12, any notice issued by the, I don't think it is necessary, kindly come to 15. 15.
Yes.
Procedure in inquiry. Procedure in inquiry before the disciplinary committee. Yes,
the procedure in inquiry before the disciplinary committee is not governed by regulation 15.
Yes.
Kindly take note of 15.4. Except as otherwise provided in these regulations, the disciplinary committee shall have the power to regulate its procedure in such manner as it considers just and expedient. So, my lord, it is the procedure is, my lord, handmaid of justice. My lord, if the disciplinary committee felt, my lord, that they would hear, because there were not just complaint, but there are documents, my lord, which were annexed to the complaint. So obviously, my lord, disciplinary committee perhaps felt that
there is a bar to calling.
There is no bar, and Lord, this is in compliance with the principles of natural justice also. So, my lord, and I can't say, my lord, the petitioner before your lordship, Lord, they can't say that they are prejudiced by that fact. If a hearing is called, Lord, it's not that any fresh documents were taken on record or something which was accepted which went against them. That did not happen in the process of inquiry. So in the process of inquiry, if they had called for some explanation or permitted appearance, that can't be said to be any prejudicial act. And there is no bar as such. Even at the stage of the report, after the report, Lord, the procedure in say, regulation 15.5, your lordships will kindly see where during the course of an inquiry there occurs a change in the members of the disciplinary committee or for any reason whatsoever, any party to the inquiry may demand that the inquiry be held de novo.
That is
So,
not
Lord,
applicable.
No, that is because it implies that, Lord, I am apprised of the fact that something change is happening. Then, Lord, it also gives my client a right to apply for de novo. That is what is contemplated. It's basically contemplated. Everybody should be kept in the loop. It's as simple as that.
So you say that you are also any party contemplating.
Any party means I am also a party because a complainant is treated as a party. But as I said, if there was a complete bar saying that no hearing will be given,
then it would vitiate.
But if there is no bar and procedurally,
a procedure is decided by them, therefore they could. That does not vitiate.
Even before the council, Lord, we recorded before the council that we are happy with the report filed by the disciplinary committee. We don't want to add anything. I'll show your lordships to that. Basically, council, Lord, wanted to ascertain whether we have wanted to say anything else, because not all the charges were allowed by the disciplinary committee. Disciplinary committee, Lord, allowed only 3 charges.
But Mr. Mitra's point was also probably that the council could not give you any hearing.
Right. If your lordships, Lord, kindly
by 17.
Governed by 17. Yes. Kindly see, it lays down the procedure with the council. It says that the report will be forwarded. Then, Lord, they will be given a chance to make a representation. If your lordships kindly sees 17.
And 16.2 also. 16.2 is what you
16.2, my learned friend wants to rely on.
16.2, yes.
16.2, then
Where the finding of the disciplinary committee is that the respondent is guilty of professional or other misconduct, a copy of the report of the disciplinary committee shall be furnished to the respondent. He shall be given an opportunity of making a representation in writing to the council. This is a right of representation to the finding of guilt. This is in nobody's case that this was also forwarded to me for any remarks. This is done for the purpose of giving Lord opportunity to the person who is found guilty by the disciplinary committee, so that he can make representation. This is like Lord in the disciplinary committee, disciplinary actions also. The inquiry report is circulated, and Lord person Lord.
3 says that council shall consider the report of the disciplinary committee along with the representation in writing of the respondent.
And if in its
opinion. So therefore, these two are only to be considered.
Right. It is nobody's case that Lord council has considered anything else.
Yes, but they have given you a full-fledged hearing.
They called us. They have called us to know whether we have any grievance against the disciplinary committee report, and we had said, I'll show your lordship from the order itself. We had said that that is what we want. We are not
apparently treated as an adversarial, proceeding.
It is not treated as an adversarial as such. Lord, they were given full opportunity. There is no doubt about it. Additionally, we were also heard to the extent that not all the allegations were allowed by the disciplinary authority. So, Lord, we did not raise any issues there. We said we are happy with the report of the disciplinary authority. This is what it is. Now, Lord, the question is, Lord, whether that has prejudiced them. The issue has to be judged on the anvil of prejudice, because even before the proceedings before the council, it is not, Lord, regulation does not say that they would not be entitled to call or heard.
So
Here
no bar, no prejudice.
No bar, no prejudice. So, Lord, the regulations will have to be read for the purpose of, Lord, finding out the procedure, whether the procedure has been followed. I can understand, Lord, the council permitting us to bring in fresh documents, or Lord, giving us opportunity of adducing evidence. Nothing of that sort happened. Whatever happened, happened before the disciplinary authority.
The council.
The substance of it is that there was no procedural irregularity which could have prejudiced them. Now, Lord, if I may just give an overview of the issues before the disciplinary authority. Now, Lord, the complaint was lodged with the council. My clients are the 3 members of the Chartered Accountant Institute. Now, Lord, incidentally, the complainant number 3 is employed by the Keshuram Industries Limited as a chartered accountant. Now, Lord, much has been said on this, but Lord, the allegations are of professional misconduct. Either, Lord, that professional misconduct is made out on the face of it, or, Lord, it fails. The professional misconduct fails. Apparently, only 3 charges have been accepted by the disciplinary authority and the council. The others have not. So, Lord, no one can say that, Lord, whatever I said was accepted by the council. Now, Lord, let us see, Lord, what are those charges. I'll just give an overview of the charges and how it has been dealt with. This is, Lord, in short, Lord, would be my submission. I had made extensive argument, but I'll just give an overview of the matter. Now, Lord, kindly come to the complaint, which starts at page 18A. 18, page 18. This is
oh, page bar koriস জিনিসটা আমি page bar koriস শোনো না কেন
Lord, please come to page 18A. It starts. Come to page 25. Oh, Lord, kindly have the opposition, Lord.
Opposition.
Opposition of the council. This is not the নাম্বারটা বল অন্য নাম্বারটা আছে এসিএ 5 টা দেখ
এটারই অপোজিশন
আগের দিন ছিল কিন্তু ওইটার মধ্যে নেই তো ওই অন্য ফাইলগুলোর মধ্যে নেই তো উপরে আছে কিছু ফাইল
These are the acts and regulations.
No, but there are some files in
These,
front.
acha, maybe. No, these are citations. তার তলায় এগুলো না হারিয়ে যায় আবার রাখবার সময় এই একই করেসপন্ডিং ওনার কপিগুলো
পেজ 110 এক্সট্রা কপি আছে একটা কপি আছে কোনোভাবে এখানে থেকে বেরিয়ে গেছে রেগুলার নয় একটু মোটা হবে এটা পেজ 117 ফিজিক্যাল কপি আছে সব কপি এগুলো থাকলে পারতো হ্যাঁ হ্যাঁ
না ওটা ওই রেগুলেশন
আর এই এই নাম্বারটা বল নাম্বারটা এসিএ 5 টা দেখছি এসিএ 5 টা দেখছি দুটো ম্যাটার আছে অন্য ম্যাটারের সঙ্গে ঢুকে যায়নি তো কনভেন্সেস আর
এই করতে গিয়ে না ভুলে যায় আবার
5 নম্বর
ছয় হয়তো 6 ঢুকে
ছয় চলে গেছে
হতে পারে হতে পারে পসিবল
হতে পারে
না না একটা কপি কি করে হবে
ছয়টা has gone for 6
এখানে এখানে না নোট করুন
আমাদের রেগুলার অ্যাপ্লিকেশন বেশি
না না লাস্ট টাইম দেখিয়েছিলাম আচ্ছা একটা কপি তো দাও আর একটা আইপ্যাড
No, papers are coming. It will multiply papers.
বাবা ওটা যা ধুলো আছে ডাস্ট অ্যালার্জি হয়ে যাবে
এত নাড়াচাড়া হয়েছে হাত দিও না হাত দিও না ঝাঁটার একটা বালতি নিয়ে এসো এটা এমনি ঝাড়নে হবে না ওটা নিচে নামো ওটা বিচ্ছিন্ন করে রাখো
হ্যাঁ না এও ইনস্টিটিউট ও এও আমাদের সব
সব ঝাড়নে হারিয়ে গেলে তো মুশকিল পরের জন্য পাবো না
May 24
ওইগুলো
হ্যাঁ অ্যাফিডেভিটের ডেটটা বল
18 May 2014
আছে
একটু বাইরে থেকে ঝেড়ে নিন ওটা
we prefer to keep matters internal so
I instead of dusting it here I thought
we won't take the trouble একটু নিচে নামিয়ে বাঁধি করে একটু ঝাড়ো এখানেই ঝেড়ো তাহলে আবার এখানেই সবার মুখে ঝুঁকবে না তুমি পক্ষে করছি ভালো দিয়ে ভালো করে হাত ধুয়ে
খুব সুবিধা হয়ে গেছে পয়েন্ট বেরিয়ে আছে
তুমি রুমাল বেঁধে বসে রুমাল বেঁধে নাকি মাস্ক রুমাল তেরো থেকে পড়ে আছে কিছু সময় হচ্ছে চলতে চলতে আমরা যদি রিটায়ার করে যাই তাহলে এটা we have to finish it before our retirement
but
pending since
I'll try to finish it today itself I'll just give your lordship
2013 so
no we progressed a lot but in between there was a change in the determination as a result that combination your lordship's combination change
yes
that is the main reason.
So that progress started much later I mean, this is of 2013
no that progress started after your lordship took up this appeal in fact before
that's why these were assigned
one fine date was called on
The Jishnu Chaudhary, in his usual youthful exuberance, said, I will do it. And they'll fix it next
And he
week.
said 15 minutes.
With 15 minutes. So I was then entrusted to get ready to do the matter next week. It was such a bad time. I had to a lot of midnight candle had to burn to.
I remember I was with him.
Yes.
He said 15 minutes matter will get done.
After that, I have not seen Mr. Jishnu Chaudhary.
No, he's not.
No. Neither have we.
He got me stuck, but in a way, it's good.
He was there
getting
for
over.
15 minutes.
But it's getting over. I am very happy.
Excellent.
Lord, please come to page 18A, which is Lord annexure to this affidavit. Page 18A.
You will be relying on how many volumes today? Now?
Not just this one and Amader Oi.
Give the other page number so that we can get prepared the other.
I'll just give it, Lordship. Now, we ye Amader order order of the council. Page number. That is appeal page 82. This is main appeal page 82.
Yes. 18A, Mr.
Yes.
Court.
Lord, it starts there. Please come to page 25.
25 years. It was placed on the complaint.
Kindly, Lord, take paragraph 11.
Yes. You placed it actually on the last.
Yes, Lord. I'll just not give.
No, please. Absolutely.
The Calcutta firm apparently has 5 branches at New Delhi, Mumbai, Chennai, Bangalore, and Jaipur. From the records of the institute, it appears that the same registration number has been given to the said 5 branches. Such registration number is such and such, which is also the registration number of the Calcutta firm at its Calcutta address. Further and fuller particulars of the 5 branches, so far as they are available, presently are set out in a schedule. Then B. The complainant shall rely upon a partnership deed dated 1st April 2002, the annual accounts for the year ending 31st March 2004, relating to assessment year 2004-5, the computation of income for the said assessment year and the statement of partners capital account and other schedules, as also the statement under 44AB of the Income Tax Act 1961, all relating to Calcutta firm, whereon are hereto annexed and collectively. These are the documents, Lord, which were annexed to show that actually the firm has 3 partners, but Lord, the others are added in Form 18, which is filed with the Institute of Chartered Accountants. Now, Lord, then, Lord, the details, Lord, if your Lordships kindly come to see, Lordships will find that in so far as the Calcutta firm is concerned, it says the Calcutta firm purports to be a partnership between 14 persons. In actual point of fact, it is a partnership of only 3 persons. Similarly, Lord, in paragraph 12 talks about Mumbai. Lord, this continues. If your Lordships, Lord, straight away come to this, gives details of who is there, who's the partner, who's not the partner, etc. Then, Lord, your Lordships come to paragraph 14. In this way, the Jaipur and the other firms are dealt with. Your Lordships will kindly come to paragraph 14. Paragraph 14 is at page 35. The complainants further state that the names of 14 persons as partners of the Calcutta firm with its 5 branches has been furnished to the institute with false and fraudulent and malafide motive. The object of giving such wrong data was inter alia to project an impression that the Calcutta firm and its branches were and are entitled to undertake both statutory and tax audits of the companies far beyond the limitation prescribed under Section 224 of the Companies Act 1956 and the notification issued by the institute more fully mentioned hereinafter. So, Lord, this is one allegation. They are accepting both statutory and tax audit beyond the permissible limit. This is one. Lord, 14 to 17, if your Lordship straight away come to 17, it says the complaint states that exactly similar wrong purpose, the names of persons who is in reality are not partners have been shown to be partners in Mumbai, etc. Lord, kindly take note from 14 to 20, these are the, Lord, in each firm, why they are inflating the number of partners is given. This is, Lord, one charge that by inflating the number of partners, they are trying to secure more audit than it is permissible in law. This is one. Then, Lord, the paragraph 21, if your lordships come to, that is at page
42.
Yes, 41.
41.
Page, sorry.
42 is 21, para 21.
Para 21. Then there is একটা page difference হচ্ছে কত. Anyway, but it says the complaint states that clause 13, part 1, schedule, etc. enjoins that a chartered accountant shall be guilty of professional misconduct if he allows a member of the institute, not being his partner, to sign on his behalf or on behalf of the firm any balance sheet, profit or loss account, report, and financial statement. So, Lord, the second allegation was that these persons who are not partners are signing the balance sheet and other documents, Lord, which they are not permitted under the provisions of the Act. This is the second charge. Now, Lord, the third charge, kindly come to paragraph 22 and 23. This is violation of section 226(3) on the ground of conflict of interest. Because, Lord, they are connected to a company, and that company is being audited. Your lordships will find that the complainants further state that section.
But these accepted. These were probably not.
These are the allegations. Lord, what was accepted is that no, this is accepted. This 6, 9, and 10 is all framed on this.
That's not relevant now.
6, 9, and 10.
No.
Conflict of interest was
has been accepted, but that has
by disciplinary
no. But then it is pending reference. That is referred to.
That is the other. That is the other.
The subject matter of this writ petition.
Because, Lord, there are two parts of the recommendation. One is they are seeking permission of the High Court to impose a punishment of 6 months suspension of license. That is pending before your lordship. And the other part is this one, this inflation. Now, Lord, these are the three broad heads of my charges. Now, Lord, kindly straight away.
Inflation টা আমাদের ফেভারে আছে। ওটা আমাদের ফেভারে আছে।
দেখাচ্ছি সেটা। Lord, kindly see the order of the council, where, Lord, the order of the disciplinary committee is set out, and then, Lord, the council.
মোটা বলতে আমি পেপারটাকে বলছি।
This is page 82, Lord. The report starts.
Yes.
So far as, Lord, charge 1, 4, 6, 9, and 10. These are the charges which have been held to be valid. Now, Lord, please come to page 100. Paragraph 5. Paragraph 5.
Yes.
This is, Lord, the first, Lord, they set out the finding of the disciplinary committee. Paragraph 5. While arriving at its aforesaid conclusion, the disciplinary committee had relied on the following reasoning arguments. Charge number 1. Kindly see 5.1.1. The photocopies of all documents filed by the complainants, partnership deed, annual accounts, tax audit, etc., is taken note.
Go into these details, Mr. Cord.
No, I am just saying
there is
that
particular
the finding was, if
Yes.
your lordships kindly come to page, kindly give me 1 minute. I'll just give the finding.
Yes.
Just finding a page about. But it comes to a finding, the lordships gives me 1 minute.
Yes.
No. Lord, please come to paragraph 5.1.12, page 107.
Yes.
The respondents could not produce partnership deed in support of their contention in Form 18 under serial number 3C. Whether the partnership under serial number 3C, that is, whether the partnership is supported by a deed, to which the answer was yes. Lord, when they filed the Form 18, they had mentioned several names as partners. And at the end of it, where the question was that is this founded in a deed of partnership, they said yes. Then this is a factual finding which is recorded. In view of the aforesaid, the committee was of the considered opinion that the respondents were responsible for filing false particulars of partnership of Mrs. Lodha and Company, so and so. In view of the above, the committee wishes to point to the respondents have either filed false particulars in the institute and empanelling authorities or furnished, etc. Then this is an act which is unbecoming of a chartered accountant. Accordingly, the committee was of the opinion that the respondents were guilty of professional misconduct falling within the meaning of clause 1 of part 3 of the first schedule, read with so and so. So, my lord, what the finding is that Form 18 is not corroborated by a deed of partnership. Even during the hearing, they have failed to produce a deed of partnership corroborating their statement as they disclosed in the Form 8, which was filed in the institute for the purpose of obtaining registration. Now, my lord, this is a finding on charge 1. Charge 4, my lord, kindly come to paragraph 5.3109.
These were the committee's findings.
Committee. This is committee.
But this is a discussion by the council.
This is council, my lord, sets out
the committees.
They set out, my lord, what is the finding by the committee first, and then they give their own reasoning. Now, my lord, 5.3.2. Because, Lord, they say that we are registered with CAG and other authorities. They say the 5.3.1 first it records admittedly the respondents and firm have filed some particulars with empanelling authorities which they filed with the institute in the form number 18, etc. In view of the finding, the committee was of the opinion that the respondents have filed false particulars with the empanelling authorities too. So far as the disposal of the complaints with CNG and other authorities is concerned, the committee cannot take cognizance of the documents shown to the committee because the same or their copies was neither filed before it nor shown or confronted by the complainants. Further, the facts and proceedings before CNG and other authorities are not before the committee. The committee thus it is not inclined to place reliance on such matters. Lord, what had happened is that they wanted to produce certain documents, they never showed it to us. They produced it before the committee. Committee says, if you disclose the document, show it to other side, we will permit. That was not done. So the committee says that that oral assertion will not be accepted. That is what the committee says. And insofar as Form 18 is concerned, that was not substantiated by production of any document or partnership. These are all, Lord, some other documents with regard to the.
Wasn't it your onus to show? I mean, where they have produced?
Yes,
where they have stated falsely. You had produced that 14 partner document.
No, I have produced, Lord, the partnership deed of 2002. May I just show your lordship that partnership deed?
That speaks about 14.
3. Partnership deed followed by their declaration under section 44 of the Income Tax Act. The balance sheets in respect of
all those say 14.
All say 3. All say 3.
So what did you produce to show that they have represented that they have 14 partners? In the
my case is 14. There are no 14 partners. There are only 3 partners. The 3 Lodhas.
So you produce documents to
substantiate that. The documents
are. Cases it's 14.
Their case is 14. Their case is 14.
Total 14. 3 were probably profit. Yes.
Lord, in so far as profit sharing is concerned, the balance sheets that we have produced under and their declaration under section 44 of the Income Tax Act, they are all, Lord, relating to 3 partners. Lord, these documents which we produced, they clearly established that there are 3 partners. Whereas, in contrast, the form that they had filed with the institute, they had shown that there are 14 partners. And at the bottom of the form, there is a column which says that if this is supported by a deed, partnership deed? Answer is yes. That partnership deed was never produced. when I place the order of the council, your lordships will find that the council clearly records that there is a mismatch in the form itself.
But that was produced by them secretively to the council.
To the
that was
council.
to the
But
DC.
no, this was produced. This form was produced to the institute.
Form was produced
for the purpose of originally obtaining, Lord, the registration. Because, Lord, if the registration shows
that is a part of the records of the institute itself.
Absolutely. And if the registration shows that they have 14 partners, they are entitled to tax audit and statutory audit for equivalent, Lord, number more than 3. Because if there are 3 partners and there are 14 partners, that will make a difference.
Yes. So there was an incentive for them to do this misconduct as per you.
Right. Lord, this is Lord, charge number 4 is actually, Lord, part of charge number 1. Now, Lord, if your lordships, Lord, 6, 9 and 10, I am not, Lord, showing your lordships now. Let us, Lord, see, so far as the finding of the council is concerned, please come to paragraph 8 at page 117. 117.
Yes.
The council considered the report of the disciplinary committee along with the written representations of 9th April, 11th April and certain documents submitted by the authorized representative of the complainants. At the time of consideration report of the and also so-and-so, the council also considered the written representation, etc. Then charge number 1. The respondent submitted their written representation on the report of the disciplinary committee, which was inter alia as under 8.1.1. The Income Tax Department had passed an order on 10th March 2011, wherein it had reassessed tax of Lodha and Company, Kolkata for the assessment year 2004-05. The assessment was done by the department after several hearings were held in the matter. By this order, the Income Tax Department added back the amount of salaries paid to the salaried partners of the firm amounting to so and so against expenditure not taken into account while calculating allowing remuneration payable, etc. The Income Tax Department, after examination of various documents, including the partnership deed dated 31st December 2001, which refers to all 14 partners, and subsequently partnership deed dated 18th December 2003, by which the number of partners increased to 17. Lord, this 2001 document or the 2003 document was not produced. We produced a 2002 document, partnership deed of 2002. And it says nature of partnership, them, and explained all the persons named the said deed of partnership proceed on that basis. Accordingly, in terms of reassessment order, there remain no deficiency furnished in the form 18, and on that basis, all the income tax assessment for the relevant period have been done. They wanted to produce these assessment orders to show that there is no deficiency insofar as form 18 is concerned. Now, Lord, your find. I'm so sorry, Lord.
Okay. Then we'll continue.
10 minutes, Lord. On next day, I'll conclude.
Hard in part. List the matter on February 11, 2026 for further hearing.
I have my Lord leave to mention a matter, my Lord. These are items 26 to 27 on my Lord's daily list. My Lord, I have mentioned this matter to, my Lord, inform my Lords of an order passed by the Honorable Supreme Court. My Lord, stating, my Lord, that
directed the matters to go out of our list.
My Lord, it is directed, my Lord, that preferably my Lord, the matters be disposed of in 6 months. My
Lord, I am the respondent plaintiff in this matter. Directions to
May I hand up the order?
The direction is to dispose of in 6 months, my Lord.
Preferably with my Lord, on mine, at mine. At mine.
Your instead.
My Lord, it's a dispute between two signatories, IGM, Gold Stag, and
Yes.
So there's
my Lord, if it's my Lord's pleasure to fix the matter, my Lord, I had to bring this on record to my Lord.
My Lord, if your Lordship
appears to be mentioned on Wednesday. Order pass
grateful, my Lord. I am grateful.
Give the item numbers on a slip of paper. Ask it.
My Lord. Grateful.
To be mentioned, to be mentioned, notes file করার জন্য second part no আগে তখন পাঠাননি এর আগে the first part to be mentioned another time
extremely urgent. May I pray for an upgradation of that matter?
What is the urgency?
Lordship, an order was passed on 29 January
Yes.
asking the university to carry out registration as well as giving admission to the students who had been barred because there was a DRT proceeding and land has been taken over by the in basis of DRT proceedings. So we had written to them in June saying that there is no admission and there can be no affiliation for this present year. In spite of that, students have been admitted, and it was in that court, the order is very clear. We are saying in under Order 39 Rule 2A, the order has been modified to the extent that within 72 hours I have to carry out this order. Otherwise, I will face.
You are not enjoying any interim order.
No.
At the time of admission, there was no interim order.
No, there was no.
What is order 41?
Order 41.
Specially fix it will appear at the top.
I'm grateful. And may I
Is any
correct the
caveat? Yes.
No, there is no caveat. But may I correct the defect? I see that the name of the judge was not given.
We'll give you the liberty when we take up the matter.
Okay.
Maybe. I'm praying for inclusion in the list under the heading application.
Application, we have several.
There is urgency where ex parte interim order has been passed.
Maybe, but let us dispose of some applications.
Order 43 inclusion.
Order 41.
Is order 41 inclusion?
No, not right now. Yeah.
But there is some urgency, my lord, because
Not right now.
where my right has been.
May I seek your lordship's kindly to mention this matter? This is a review application of your lordship's order. Lordship, the urgency that I'm attempting to canvass is your lordship at
This bench.
This bench. Suit for declaration, your lordship.
Review application.
Review
applications we will take up next week. Let us dispose of some.
Urgency. I will not, your lordship. Your lordship, next week, if your lordship can list it, I can.
Next week, come on, you can mention.
May I mention one matter, your lordship? Leave to file without certified copy.
Yes.
But inclusion in the list, my lord, under order 41 rule 11, my lord, application.
Next week, come next week. Call us.
Also, item number 1, I am led by Mr. DN's. I am for the appellant, my lord. Mr. Sharma is leading me, my lord. He is on his way. My lord, what in this matter, my lord, what has happened, my lord?
Your application,
my lord.
Can
5 is my
5 is their application for expedite hearing, my lord.
That will allow expeditious hearing.
I am led by
Unless Mr. Sharma opposes the expeditious hearing application.
No, I'm not opposing that. But they have made very serious allegation in the early hearing application, saying that we have misled the court to obtain an order and that the suit is void. Normally, when early hearing we don't use these phrases. So, kindly, my lord.
We'll just We'll say, Mr. Sharma, that the allegations are deemed to be denied.
Lordship, those allegations shall not be deemed to be admitted. And
no, definitely. We'll say that.
My lord, kindly fix any time, my lord, because it is.
You want to prepare paper books on this?
Yes, my lord. Everything is
already prepared.
It's ready for hearing.
But there's an application we have filed.
There are filed application for CAN 5.
Contempt and
CAN 5 is yours.
No. Their application.
My two things.
CAN 5 is early hearing.
No,
CAN 5 for CAN 4 for some additional document.
That will be heard along with the appeal.
Yes, my lord. My lord, I served them the opposition. My lord, kindly allow me to
two
file.
things are left on our part.
Yes,
because of long.
Let me finish first.
Achha,
kindly allow me to file the written objection.
No, finish first.
Oh,
we'll allow
and that is the first step. Kindly fix any time, my lord. Otherwise, it is just coming, my lord. I am suffering unnecessary order.
First thing, what is the order you are suffering?
Status quo.
Regarding what?
Of any dealing with the property. That is
that urgency is available to 90% of these matters in our list. Why should you put it at the top of the list? Why should you jump the queue and come before other matters?
I am suffering, but
everybody is suffering here.
I'll suffer.
We are also suffering your sufferings.
I'll suffer. I'll satisfy your lordship. But shoot is a void shoot, my lord.
Maybe we cannot give precedence to your matter. At best, we can direct it to appear in the hearing list. That is the utmost we can do.
I'm
yes, Mr. Sharma, what is
the application?
There's an application for contempt also pending CRC 11 or 2023. May it be taken up along with the matter when lordship takes up the matter.
CAN 5 of 2025 is an application for early hearing of the appeal. Pushab Learned Senior Counsel appealing for the appellant stroke opposite parties submits that serious allegations have been leveled in the application, which the appellants stroke opposite parties squarely deny. Pushab next para. Since the prayer in the application is innocuous, and we do not invite affidavits, comma, it is deemed that none of the allegations made in the application are admitted by the appellant stroke opposite parties. Full stop, next para. The affidavit in opposition filed by the respondent to the application under Order 41 Rule 27 of the Code of Civil Procedure of the appellants today be kept on record. Full stop. Reply, if any, shall be filed
within
1 week.
2 weeks.
But already it was served that this was expired.
ठीक है, we are taking
No,
action.
no, one week. Within a week from date. Full stop, next para. The since the appeal is otherwise ready for hearing, comma, Can 5 of 2025 is disposed of by directing the appeal to be listed for hearing in the monthly list of March 2026. Full stop, next para.
Along with CRC 11.
The pending applications and the rule in connection with the appeal shall be listed for hearing along with the appeal.
Not, may I permit one liberty, madam? In that what it was directed that to file the affidavit. It is ready with me for
Affidavit to what?
for the in the contempt application. It is ready
Very
with me
well.
for last 2
Article 9
weeks.
Adkota, the affidavit in opposition filed in respect of the contempt application today be also taken on record. Full stop, next, sir. File it.
File reading.
Reply, if any thereto, shall be filed within a fortnight from date.
Liberty to file the copy.
Next.
Grateful.
Thank you.
I'm grateful.
Thank you. Give your appearance. Yes.
For the respondent, Your Lordship.
You deprived us of the opportunity to put the matter out of the list. Yes. What is the matter, sir? You are for the sole respondent, so both sides are there. Yes, what is the application?
Lord, this
Two
is
applications?
yes, Milord.
Condonation has been allowed?
Your Lordship.
Not allowed. So condonation first.
Milord, this is that matter, Milord, where Milord the expert wife have suffered an ex parte decree which is under challenge.
Oh, appeal along with the application. Yes.
Yes. Now, Milord.
Yes, moving
Now,
on.
Milord, memo ta deven. Now, Milord, kindly takes up the memorandum of appeal. Milord, my argument will be, Milord, non-service of summons, and since Milord, I could not, Milord, adduce evidence, I do not have much to say, Milord, on the merits, but I will show, Milord, from the Special Marriage Act, Milord, where the suit is otherwise not maintainable on a point of law.
Special Marriage Act though. Which provision of special?
Yes, Milord, kindly see. That a copy kindly see, Milord, Rule 10 of Calcutta High Court Special Marriage Act rules. Pavel now. Anyway.
Why didn't you take out photocopies of that?
The Milord pages, Milord, there is a chance, Milord, it may
You will have to keep photocopies
yes.
of the judgments of the rule. Readily not available.
Very well, very well.
Act though. But Rule 10, we won't be able to refer to the copies then.
Yes, yes, yes.
What is Rule 10? What is?
Kindly, Milord, if your Lordship will, well, I'll come to that.
Very well.
First, Milord,
Suit for divorce. Suit for divorce.
Yes. Yes. Now, Milord, kindly see, Milord, the memorandum of appeal. All the order sheets in the Milord appeal are in the suit are annexed there.
Yes.
Milord, kindly see, Milord, kindly allow me to place, Milord, all the Milord orders. Kindly see on 18th May 2023, that is the first order, the suit is registered. 17 July 2023 for SRAD, first order. Then, Milord, kindly see, then order number 2, Milord.
Order number 5 is the one.
Yes, order number 3. Order number 3, 17th July.
Yes.
Kindly see, today is fixed for filing fresh steps by petitioner, Hajira, along with other postal.
Till then it was not served. Till order 5 it was not served.
It was not served. Now,
so order 5 for the first time held that postal claims unclaimed.
Exactly.
Exactly.
So which is good service and not claimed if served several times, we don't know.
Yes, I'll now, my lord, let me show how it was served. First, my lord, order 5, my lord. Kindly see, my lord, the section 5 application. Here, my lord, the order number 19th September, order number 5, my lord, is bad for non-compliance of, my lord, order 5, rule 17 and 19 of the code. CPC. Kindly takes up section 5 application, page 46, annexure G.
Yes.
Kindly see, this is the summons which were, my lord, served by the process server. Kindly comes to, my lord, the kindly kindly see, my lord, page 49. This is, my lord, the report filed by the process server. Kindly allow me to place it, my lord. Kindly see how fraud was played upon court. Kindly see, my lord, need and, my lord, kindly see, my lord, at the top, the two witnesses, the signature of two witnesses were there, which the process server allegedly collected. Now, my lord, kindly see, নিবেদন এই নিবেদন এই যে অদ্য 28/6/2023 তারিখে দিবা অনুমান 1টার সময় পরোয়ানা লিখিত শাকিনে আসিয়া আমি সন্ধানে ও স্থানীয় লোকজনের দ্বারা সন্ধানে মোকাবিলা প্রতিবাদিনীর নাম ধরিয়া হাঁক ডাক করায় এক ভদ্র মহিলা মুখে মাস্ক পরিহিত নিজেকে প্রতিবাদিনী বলিয়া পরিচয় দেয় এবং আমার আশা এবং আশেপাশের লোকজন কহেন ইনি প্রতিবাদী আছেন। তৎসময় তাহাকে অত্র পরোয়ানা যত মর্ম অবগত
Prior to handover, she said no.
She said no.
তিনি কহেন আমি কোনো কাগজে
সাক্ষ্য করিব না. This is the report. Now, my lord, on this day, my lord, I have annexed my passport. I was not even in the country. My lord, I'll
the passport?
Yes, I'm showing that. Kindly comes to, my lord, the passport starts from annexure H, page 51. Kindly comes on the left hand side. Kindly see, my lord, arrival on 19th September 2023.
Absolutely legible. Page 51.
Page 53, my lord.
Oh, sorry.
53.
Yes.
এটা হচ্ছে সার্ভিস হচ্ছে কবে?
28/6.
Yes.
Arrival 19th September.
19th September is arrival, then departure on 28th October 2022. Then, my lord, kindly see right hand side of that passport. My lord, kindly see, my lord, I came to, my lord, India on 11th July, that round seal and stamp. That is on 2022.
Yes.
Therefore, no question of serving me on 28th June 2023.
One second.
No arrival stamp নেই আর September 2023 আগে 2023
19th September is the relevant date, 2023. When I came to India, I departed India on 28th October. On 28th October 2023.
He arrived on 11th of June, departed on 28th.
The round seal on the left hand side.
Oh, 2021 arrival.
On 2023. It is this one. So, Lordship, this round.
Yes.
At the top, 19th September 2023.
Year 2023.
Let us follow the chronology.
Relevant time is on 2023. 2022 is immaterial when I come back, because notice was according to the process server 28 June 2023. I came to India, arrived in India on 19th September 2023. I
departed on 28th of October
2023. That square stamp above, Milord, just by the side of the round stamp.
Departure.
On the same page, kindly see there are two 28th October. One is 28th October 2022. That is below the round stamp. We are not concerned with that. The stamp just beside the, Milord, round stamp, that is 28th October 2023. Therefore, there was no question of serving me.
19th of September 2023, you had arrived.
19th, yes,
you had arrived,
yes.
and you departed on 28th of October 2023.
Yes.
The bailiff's report says
28 June 2023.
That is before this.
Yes, then
Before
I
your-
was not on that period. I was not in India. Kindly see these other stamps also. Kindly see the other stamps.
You had departed on 28th of October 2022 from the other stamps.
Yes, that is the previous year.
Yes.
We should not look at that because
No, we should look at because the period when you were not there. हाँ, exactly. Exactly. So you departed on 28th of October 2022 and returned on 19th of September 2023.
Yes.
In between, it was served.
Yes.
No.
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 2023.
You are forgetting your own
yes,
period.
yes,
We are
20
calculating and you are.
Yes, that
The other dates are immaterial.
immaterial.
During this relevant period, your last departure is shown as all the others are before that. Last departed on 28th of October 2022, returned on 19th of September 23.
Exactly.
So in between it was served.
In between it
Allegedly.
was served, and my lord, I was wearing a mask. I did not receive. Therefore, my lord, kindly, my lord, again see, my lord, order number 5.
Yes.
Now, my lord, kindly see, my lord, what the order says. Hajira has filed before today on behalf of the petitioner. One AD card is received along with the sealed envelope with a postal remarks as unclaimed. Postal remarks unclaimed must be in that period. Must be in that period. Upon perusal of the case record, it appears that ESA through process server is lying in case record, wherefrom it appears that the addressee has refused to sign the service return. In view of the above fact, I am of the opinion that refusal by the respondent to receive summon is a good service, and the suit shall, my lord, henceforth proceed ex parte. Now, my lord, kindly see, my lord, the plaint which is annexed at page 19 of the, my lord, section 5 application.
Yes.
Kindly see at page 20, what is the address given?
Yes.
Priyam Mollik Ni Jatua, wife of Biplav Mollik, daughter of Anando Jatua, residing at 13 Rajani Kumar Kanto Shen Lane, PS and District Howrah, pin code such and such. Milord, what is their pleading regarding this? They say
Living with your boyfriend there.
yes. I am kindly see, Milord, paragraph 16 of the plaint at page 27. (16, 17, 18). And that's why I was served, Milord, notice on that. Specifically paragraph 15. Specifically paragraph 15.
Yes.
Now, Milord, kindly comes to the last, Milord. Milord, again, Milord, my passport, which is at page 51. Kindly see the address, Raghunathpur, place of birth, Raghunathpur, West Bengal, where I was born. This is not the address. These are, my lord, my...
It was place of birth.
Yes.
But your address is 59, page 59. What is that?
Page 59. No, this is the last page.
That shows your address.
This is not the address in which it was shown.
This is a paternal address.
Paternal
Your
address.
place of birth is not interesting to us.
A paternal address.
Page 59.
Yes, this is the last page of the passport.
Very well.
Then, my lord, kindly see page 60. Aadhaar card at the top, my lord, kindly see my address is given. The same address.
Yes.
Kindly see page 61. This is the ration card. Kindly see, my lord, after the QR code, it's bit, my lord, illegible. After the QR code, kindly see AB address, AB3 and the middle, my lord.
Yes.
Same address. Then, my lord, kindly see page 62.
Huh.
62, my lord. This is the, my lord, electoral voters identity card, my lord. Kindly see page 63. Address is given.
Yes.
Same address. It was not, my lord, had it been, my lord, sent to at least my paternal address, my lord, and at that point of time, both the parties were, my lord, residing together, my lord, at Dubai. My lord, once upon a time, my lord, the husband, my lord, came to India, filed suit, not informed anything, went away. Even when the child was born, the husband was present in the birth certificate of the child, father's name is here, after, my lord, the divorce. Now, my lord, here, my lord, what is, kindly see what is the ground in the suit. Ground is mainly, my lord, wife is leading an adulterous life, as a consequence of which the husband has suffered mental cruelty. Here, my lord, I wanted to show, my lord, and I have got another copy, my lord. ঠিক আছে, বই আছে। Kindly see, my lord, Rule 10. Calcutta High Court Special Marriage Act Rules, my lord, 1955. Rule 10.
Yes.
Lord, may I place? In every petition for divorce on the ground of adultery, the alleged adulterer shall be impleaded as a co-respondent, provided that the court may, on being satisfied that the petitioner has not been able to ascertain the same and identity of the alleged adulterer, excuse the petitioner from so impleading him. Provided further that if the court has so excused the petitioner, the identity of the alleged adulterer in the adultery is discovered, the fact must be brought to the notice of the court, and that the court shall thereafter pass such order as it may think fit. So this is, my lord, not there in the, my lord, Hindu Marriage Act rules, but this is, my lord, there in the Special Marriage Act rules. And I could not find, my lord, from any of the orders, my lord, this exemption was ever claimed for. Adulterer was not made a party to the suit. (17 and 19).
Yes. What else?
Now, my lord, kindly see, my lord, for your lordship recapitulation, Order 5, Rule 19.
What would be the effect of non-compliance of this?
Non-compliance of this, my lord.
The procedural irregularity, because it's a part of the rules.
No, rules, yes.
These rules are framed under which provision?
By our full court, my lord.
No, under which
The
legal provision? Power to make rules.
Act. In the Act.
In the Act. Central government, state government may, but how can the High Court? 41. My learned brother points out.
Yes.
To 2A specifically provides.
Yes. Yes. Including the petition reason.
After all, it's procedural then.
But this is a Miller defect because on Millard, otherwise I cannot go into the merits. I have no written statement, no Millard.
No, that's different.
But if your lordship Millard kindly see Millard order 5 rules,
Yes.
17 Millard the Calcutta amendment.
We don't have the Calcutta amendment. Unfortunately. CPC আর কোনো আছে?
নতুন বই তো।
দেখি।
That is a new book.
This should be there. আর CPC টা আছে? ওখানে তলা দিকে সেকেন্ড, ডান দিকে তলা থেকে সেকেন্ড বইটা। একদম ডান দিক, একদম ডান দিক। তোমার বাঁ হাত তলা থেকে সেকেন্ড। ওটা কি CPC? আচ্ছা, এখানে সেকেন্ড রোটায় থার্ডটা ওটা ওটাও না, আর ওই সাইজের কিছু নেই, ছেড়ে দিন। দেখি এটা, হ্যাঁ ঠিক আছে। You don't have a book.
17, 19 টা বার কর। Kindly see Millard 19 Millard says the procedure Millard what has to be followed. বার করছি। বার করছি।
6 এটা। 19 is May.
May, but
May not also.
But
17 is there.
17 is Calcutta amendment is there.
এটা কি আমাদেরই? এটা ফেরত দিয়ে দিন নাকি? বন্ধ করে দিলে কেন? Yes. So there is a compliance of 17 at least and 19 also.
19 Millard
That is May.
not been verified by affidavit.
No.
Amount returned under rule 17 to the court. If the return under the rule has not been verified by the serving officer and may.
But your book contains May. Our book says shall.
Then further
Which publisher?
Common House.
Our book is.
Shall.
Then shall.
Then shall. It our amendment.
He doesn't have a copy of any of the book. He must.
This is
You give her your book and you just check up, read the May as shall because it's shall now.
এই যে এইটা the মেটা এটা shall হয়ে গেছে এখন।
Just see 17 first. Calcutta, just show her the whatever you are relying on. Just to answer these.
এইটা Calcutta amendment.
কিরম সিরিয়াস ভুল করেছেন আগের দিনই বলছিলাম শ্যালকে মেয়ে করে দিয়েছি ওর মনে হচ্ছে শ্যালটা ঠিক হবে না আপনারটা কি পাবলিকেশন ইবিসি ইউনিভার্সাল দুজনেই শ্যাল বলছে কমলে তো শুক্লা
দেখো তো নেটে
কমল থেকে নেবেন না আমি কোর্টের ব্যাপারে ভুল বয়ে থাকলে কমল ঠিক আছে Shall examine and may make further inquiry.
Yes.
Not examined here and no report apparently is
At least-
mentioned at least.
Yes, yes.
But here a representation was made to the belief that she was there.
Mask.
Identified.
Mask, I mean, how can you ascertain?
So
You'll
many
open the
co-
mask and see.
So many coincidences, my lord.
Not
She is
coincidence. You
not
are
a-
wearing a mask. How can there be a coincidence?
And
Presumption of-
others, but she was
Could have drawn a
wearing mask.
presumption of service if it was a paternal address, probably. But
Others, my lord, the other, my lord, neighbors say she is Pratibha.
neighbors, everything, house address is of the boyfriend who has not been implicated. That is the difficulty.
Impleted, and my lord, kindly see the address of, my lord, the witnesses at page 49. Nowhere, my lord, they must be, my lord, the local people. Nowhere, my lord, there. Kindly see addresses. Nowhere near, my lord, the address, my lord, where the bailiff attempted to serve.
They
Kindly
may
see.
have been passers-by,
Page-
but neighbors, it says neighbors.
Neighbors, my lord, kindly see the address. Whether Rajanikanto Shen Road. No. Kindly see page 49. One is Chintamoni De Road, one is Boikuntho Chatterjee Road, lane.
What is this address?
Rajanikanto Shen.
Aura, we don't know the proximity of those two. I have absolutely no idea.
13 Rajanikanto.
Pin code is the same, it's Howrah. ESN district Howrah.
It cannot be neighbors.
Google है देखो तो.
ESN district Howrah. You don't know where Chintamoni Day Road is. Maybe neighbors, may or may not be. You have to assume.
At least minute premises number may be same. I was.
Yes, sir. কোথায়?
Yes,
Mr. Banerjee.
I was asking him only.
Mr. Banerjee, do you have any idea? Chintamoni Day?
But with regard to the other, I know that. Because
Boikuntho Chatterjee Lane, you know? Not sure. Chintamoni Day Road?
Chintamoni De Road, I know. That
Is Chintamoni Day Road near Rajani Kumar? No, that's no. Whether Chintamoni Day Road is near Rajani Kumar, Rajanikanto Shen Lane, Rajanikanto Shen Lane, you don't know. Please check your serial. So no, we can't be sure.
That this is what we got on records.
Anyway, so that is another point. But let us hear. These are your points.
These are Milord.
If your lordship kindly turn to page number 11. Paragraph 28, what is our sufficient cause for delay?
Yes.
May I read your lordship? Your petitioner states that on 13/10/2023, the plaintiff opposite party appeared before the. Oh no, I'm sorry, your lordship. It's not 28. It's no, page number 15, paragraph 37. 30.
Yes.
Your petitioner states that although your petitioner had come to know about these facts from record of trial court in the month of October 2024, it was impossible for your petitioner to take immediate steps before the court of law due to the advanced stage of pregnancy of your petitioner and the subsequent birth of the male child on 14/3/2025. That is in a first trimester. Your lordship, if your lordship kindly turn to page number 6. Paragraph 12. In the month of in the first week of August 2024, the treating doctors of your petitioner, after consulting the reports of the pathological test of your petitioner, informed your petitioner that your petitioner had conceived for the second time. That is in the month of August 2024, she had known that she had conceived. Then your lordship, just the paragraph above 12, that is in 11, She had chose to fly from Kolkata to Dubai in the month of in the date of 14th of September 2024.
First one.
Yes, and in paragraph number 13, she returned from Dubai again on 23rd of September 2024. That is in a first trimester only.
Sometime 2025.
Therefore, your lordship has sufficient cause that she could not take any step after knowing that she even known about it on 20th of September 2024, not exactly in the month of October when her parents when her father has gone to Howrah Court and received the information, your
How do you
lordship.
get that?
Yeah, paragraph 19, page 9. May I read it, your lordship? The petitioner states that the said learned advocate, after conducting thorough searches in the record department of the Howrah Court, intimated the father of your petitioner on 20th of September 2024 that the opposite party had filed a suit for dissolution of marriage, being matrimonial suit number 5 such and such before such and such court at Howrah on 18 May 2023. So she had learned about it on 20th of September 2024 and chose to come back on 23rd of September 2024.
No, but she obtained the certified copy later.
Yes, she had known on 18th of September and obtained the certified copy on
3rd October.
3rd of October.
Thorough searches, the Howrah
But
Court
she has
indicated father
admitted that she
on 20th September. 20th September, the opposite party had filed a suit and had obtained expiry degree.
she had knowledge on 20th of September 2024. And she chose to fly back from Dubai to Kolkata on 23rd of September 2024.
Right.
Now, your lordship, after coming back on 23rd of September, she did nothing. She
had flown to Dubai on
flown
14th,
from Dubai to Kolkata. She had flown
flew
to Dubai
to
on 14th of September.
14th of September. She returned on 23rd.
On 23rd, yes, your lordship. That is in the same time. That is in the same month, during her first trimester. Now, after she came back on 23rd of September, she did nothing. She waited. And then, in the month of May, she talked to an advocate in who is practicing in Calcutta High Court and filed this appeal, your lordship. Now, your lordship, I want to place some judgments with regard to sufficient cause, your lordship, and regarding coordination of delay and sufficient cause.
What about the address being wrong? First, you will complete this and then go.
Coordination of delay, your lordship.
But you have to meet the other points also. After you cite the judge, the other points taken.
Merit, your lordship. First,
No,
you
not
have
on
to
merit.
satisfy the sufficient cause.
Special Marriage Act maintainability we can understand on merit, but she was not there at the relevant time, point of time when the. Oh, very well. Since section 5 is there.
Yes, your lordship. I'm placing two judgments. The first.
What is the delay?
519 days.
519 days from the order and 200.
She learnt, according to her, on 20th of September 24.
Yes,
When
your
did she file the appeal?
Yes, your lordship. It's 9.
Filing.
And after knowledge, 247 days delay.
4th of
Appeal
June.
filed on 13 June 2025.
13 June. No. Let us check up.
Please have the filing slip here.
You have filed on 23rd of May 2025.
After she had knowledge, she waited for 247 days and then filed this application, your lordship.
What is the explanation in the interregnum after giving birth to the baby?
Only explanation on that paragraph that she's taking care of her newly born child, and that is why she did not.
The child was born when?
March.
In March.
14th March 2025.
Yes. All right. Yes, this judgment.
Yes, Your Lordship.
সাইটেশনটা দেবেন
Mhm.
এটা দেখাবি।
SLP 3124
Yes.
2018.
SLP 31
248.
OE
2018. Your Lordship, the honorable.
127.
You have the SEC citation?
No, Your Lordship, that is the SLP.
Wait.
248.
Notified, yes.
It's reportable, Your Lordship.
ওই তো ওইটাই
Yeah, the Honorable
Eka নয়।
Apex Court have referred to several judgments, Your Lordship, starting from paragraph 19. No, for condemnation of delay, it's in the paragraph 19, Your Lordship. I'm coming to page 26, paragraph 26, where the Honorable Apex Court had laid down some law regarding limitation.
Yes.
If I may read, Your Lordship. Law of limitation is based upon public policy that there should be an end to litigation by forfeiting the right to remedy rather than the right itself.
Acha, 1 minute. Have you remarried?
No, Your Lordship.
There is an injunction passed by your lordship.
Yes. Yes.
Yeah, not sure. The right or remedy that has not been exercised or availed for a long time must come to an end or cease to exist after a fixed period of time. The provisions of Limitation Act has to be construed differently, such as Section 3 has to be construed in a strict sense, whereas Section 5 has to be construed liberally. In order to advance substantial justice, though liberal approach, justice-oriented approach, or cause of substantial justice may be kept in mind, but the same cannot be used to defeat the substantial law of limitation contained in Section 3 of the Limitation Act. Now, the point 5, Your Lordship. Courts are empowered to exercise discretion to condone the delay if sufficient cause had been explained. But that exercise of power is discretionary in nature and may not be exercised even if sufficient cause is established for various factors, such as where there is an inordinate delay, negligence, or want of due diligence. Now, point 7, Your Lordship. Merits of the case are not required to be considered in condoning the delay, and delay condonation application has to be decided on the parameters laid down for condoning the delay and not condoning the delay for the reason that the conditions have been imposed tantamount to disregarding the statutory provision. In the judgment cited in referred in this same judgment, Your Lordship, I want to point paragraph 19.
Stage on the pregnant first month.
Which judgment?
Same judgment, Your Lordship, paragraph 19, where it has been referred to some in HON'BLE Ahmed and others.
Yes. Why are you going backwards?
I have read the laid down points first, Your Lordship, not the references.
Yes, 19.
The court has time and again repeated that when mandatory provision is not complied with and delay is not properly satisfactorily and convincingly explained, it ought not to condone the delay on sympathetic grounds alone. Same points in paragraph 20 and 21, Your Lordship. Now paragraph 22. No, same point, Your Lordship. 23, kindly. In the expression sufficient cause as occurring in Section 5 of the Limitation Act cannot be liberally interpreted if negligence, inaction, or lack of bona fide is writ large. It was also observed that even though limitation may harshly affect rights of the parties, but it has to be applied with all its rigor and prescribed under the statute, as the courts have no choice but to apply the law as it stands, and they have no power to condone the delay on equitable grounds. Similar is paragraph 24, Your Lordship. Paragraph 24 inside para 12, the last 1, 2, 3, 4, 5 lines, Your Lordship. The legal maxim dura lex sed lex, which means the law is hard but it is the law, stands attracted in such a situation. It has consistently been held that inconvenience is not a decisive factor to be considered while interpreting a statute. And the next paragraph, Your Lordship, it has already been underlined. No court could be justified in condoning such an inordinate delay by imposing any condition whatsoever. This is the judgment I'm placing, Your Lordship, and there is another judgment on similar grounds of condemnation of delay.
ওই যে পাতাপতি শুভ্রা ওই গাই 2024 এটা কত
অনেকগুলো। 2020 Supreme Court 3043.
Supreme Court 3043
Yes.
para
Yes, Your Lordship. Page 8, paragraph 13. Okay. It is a big paragraph, Your Lordship. If I may read from line 4, Your Lordship.
Yes.
We may state that even if the term sufficient cause has to receive liberal construction, it must squarely fall within the concept of reasonable time and proper conduct of the concerned party. The purpose of introducing liberal construction normally is to introduce the concept of reasonableness as it is understood in its general connotation. The law of limitation is a substantive law and has definite consequences on the right and obligation of a party to arise. These principles should be adhered to and applied appropriately depending on the facts and circumstances of a given case. Once a valuable right as accrued in favor of one party as a result of the failure of the other party to explain the delay by showing sufficient cause and its own conduct, it will be unreasonable to take away the right on the mere asking of the applicant, particularly when the delay is directly a result of negligence, default, or inaction of that party. Justice must be done to both parties equally, then alone the ends of justice can be achieved. If a party has been thoroughly negligent in implementing its rights and remedies, it will be equally unfair to deprive the other party of a valuable right that has accrued to it in law as a result of his acting vigilantly. The application file, this is not relevant, Your Lordship. Then the next line, the application has to be reasonable or plausible so as to persuade the court to believe that the explanation rendered is not only true, but is worthy of exercising judicial discretion in favor of the applicant. If it does not specify any of the enunciated ingredients of judicial pronouncements, then the application should be dismissed. On the other hand, if the application is bona fide and based upon true and plausible explanations, as well as reflect normal behavior of a common prudent person on part of the applicant, the court would normally tilt the judicial discretion in favor of such applicant. Liberal construction cannot be equated with doing injustice to the other party. So, Lordship, since 23rd of September,
these arguments of yours,
yes,
these are relevant for the period when she came to know, and according to her, she came to know after that.
Took no steps.
But the other points she has taken are relevant for the period before that.
That is for the merit of the case, Your
No,
Lordship.
not only for the merits of the case, because the judgment was passed on October, sometime in October,
Yes, Your Lordship.
right? So it was passed in
16th October 2023.
all right, 16th October 2023. October 2023. Now, according to her, she came to know on 20th of September 2024.
Yes, Your Lordship.
So there is 1 year between the two. So that period you are waiving. You are not arguing on that, because the service of summons is relevant for that also.
That
Because if we proceed on the premise of her submission that she actually came to know only on this date, the later date, then those are on merits.
yes,
But for the period from October when the decree was passed and when she allegedly came to know, if the service of summons was correct, then we'll not condone that period also. So you are waiving that.
I'm not waiving, Your Lordship.
Because unless you satisfy us that there was valid service of summons, we can condone. We have to condone her delay regarding that period. I mean, therefore, she did not have knowledge of the suit
Yes, Your Lordship.
and only came to know for the first time in September 2020.
Lordship, they have
That you are taking a risk, because
Yes,
if you leave that, then if we by chance allow the condonation application, then automatically she wins. She wins on the
yes,
other
Your
aspect.
Lordship, I understand.
That
Your
period
Lordship,
also you have
she
to
has-
counter,
Your Lordship, she had
not only on merits.
she's argued, Your Lordship, that she has been living with him in Dubai and for the entire time, and he had cheated by filing the divorce case here, while
She does not say she's living with him in Dubai. Does she say that?
yes,
Was
they
at
have.
that point of time.
With that
She was-
gentleman?
When the suit
With
was
whom?
filed-
With him?
With him.
No, your lordship.
him.
That is the point I'm taking. If your lordship kindly took up the affidavit in opposition, I have filed.
Yes.
Your lordship, annexure A1. She had already left her husband there and she was living separately. That is not disclosed in the petition anywhere that they have filed in the appeal. They have all along they have
You are writing this.
Yes, your lordship. She had left the.
You are writing. Your email does not.
No, that email he has sent to her, and she was working there in.
Your email does not. I mean, cannot be taken as her.
But it was sent to her. She did
Might
not,
have sent you. That might have been your perception. That does
saying
not establish that she had a relation.
she was not living with.
Why
him.
didn't you also serve on her parental address, which was her permanent residence? Your entire case is based on adultery. You don't implicate that person. The address given, her address given is of that person.
Yes, your lordship.
I mean, it's a very, very thin ground you are standing on. No, you cannot improve it, but we understand that. But because you only address given is of that alleged boyfriend whom you do not implicate, I mean,
Yes, sir,
barely
I
name in
understand.
the.
I understand.
That's very difficult. For that period, it's very difficult for us to condone. So we'll have to focus on only the other period.
The
So you are
period
relying on this.
247 days, your lordship. That she
Whatever
had
it is, I
not-
mean, from knowledge, yes, from knowledge.
Yes, your lordship, from knowledge.
This is all. Good arguments. Take your seat. Mr. Bhattacharya, how do you explain this? You flew to Dubai, you came back
No.
in September,
Yes.
and in October, and in September itself. Between the period when you went and you came back, the knowledge was derived by your father.
Exactly so. Exactly. Milord.
So you came back from Dubai and then became so incapacitated due to your pregnancy that you could not.
Due to Milord, advanced. Kindly see, Milord.
It became advanced after you flew back from Dubai.
Milord, first knowledge.
The next day you could have done.
Yes, true. Milord, kindly see, Milord. In August, Milord, Milord.
You knew about the pregnancy in August.
August 2024. That is, I was pregnant with the Milord for the second time.
You are forgetting that in 2 months it became so advanced that you could not contact your advocate. You are forgetting that part. But we can't forget this, that you knew about the pregnancy for the first time in August.
Yes.
Now you flew to Dubai after that, 1 month after that, on 14th of September 2024. Still understood. You returned on 23rd of September 2024. In the meantime, your father had already known. So when you come back from Dubai, you fly from Dubai on 23rd of September 2024. Your father already had knowledge. So the moment you land or before that, you had knowledge. So if you could come back from Dubai by flight on 23rd, why couldn't you go to your advocate on 24th?
Milord,
Or 25th or 26th?
That Milord, I was advised bed rest. Milord, this is Milord.
Because of the stress of the flight.
I cannot, Milord, improve more on this, Milord. This is the
That's not
instruction-
credible, Mr. Bhattacharya.
Instruction, Milord, at page 44.
That's not credible. That's not very credible.
At page 44, Milord, this is how, Milord. But, Milord, whatever, Milord, yes, that I have, Milord, due to, Milord, it can't be, Milord.
Your negligence is palpable. Now the judgments are very stringent.
Definitely.
Forget the previous days.
No, negligence. If I may borrow, Milord, kindly, if your
This is not negligence.
Yes, definitely, Milord. If your lordship would kind enough to see para 13 of Milord, the reported judgment, Milord, which my learned friend has cited, Milord, 2010 Supreme Court, Balwant Singh. Kindly see, Milord, paragraph 13, that the middle portion, Milord. This is not a case of extreme lack of bona fideness. My case. This
in other places it has been when the delay is directly a result of negligence, default, or inaction. That was not a case of extreme. But it was held that when the delay is directly a result of negligence, default, or inaction of the party.
Yes, let me check up the delay, Milord, period of delay here, Milord.
Period of delay is immaterial, but negligence, default, or inaction even for a few weeks may be sufficient.
That is there, Milord.
And here it's not a few weeks, it's about, so many months.
Yes,
you knew in September.
519 days.
From your knowledge.
No, 247.
No, from your knowledge, you are taking now from your knowledge.
Yes, 247.
240, almost a year. 3/4 of a year.
9 months.
This is there. Page.
This is utter inaction.
Milord, I
Sat
cannot-
tight over the
yes,
matter.
Yes, Milord, not sat tight, Milord, since
Sat
due to-
loosely over the matter.
Due to
But
Milord,
you sat over the matter.
second pregnancy, Milord, the client, Milord, could.
Why second pregnancy? Why are you projecting this?
But the health issues, Milord. Whatever may be the reason, health issue. Kindly see page 44.
With that health issue, you flew to Dubai.
That is, Milord, to.
In August, you knew about the second pregnancy. After the knowledge, you became so weak and so tired that you flew out to Dubai.
Then, Milord,
Not credible.
this is there, Milord.
Flew to Dubai. She has established from your paragraphs.
Yes, Milord. My.
So the chronology stands. Second or fifth or 10th time you became pregnant, we are not interested.
Yes.
You
Whatever
knew
the
about
claim
your
is.
pregnancy, Mr. Bhattacharya, because we hate to repeat the word time and again, but that's your ground, so we have to center around that. So in August, you came to know about the fact.
Yes.
On 14th of September, about a month after that, or half a month after that, 2 weeks after that, you flew to Dubai. And then you come back later part of the same month, 23rd of September. 23rd of September, you already know that you have he has obtained a divorce. So you wait for 1 year. Acha, very well. Why did you have to wait for? Because the son was born on March, 14th March. So from September to March, I mean, for 6 months you were in such an advanced stage of pregnancy for 6 months.
Milord,
What is advanced to you?
No, not advanced, Milord.
For 6 months you were in advanced stage of pregnancy.
Can't be, Milord. But I was, Milord, advised, Milord, complete bed rest, Milord. That is also there.
A doctor certificate is there. Where is that?
Page 44.
Your Lordship, in paragraph 12, once again, they have mentioned that the doctor has advised him bed rest. Yet she chose to fly on 14th of.
Doctor advised bed rest when?
Milord, page 44, Milord, 1st of August.
In August itself?
Yes.
After which you
No,
flew to Dubai?
Yes, kindly, Milord, kindly see, Milord.
Yes. Paragraph 13. She discarded the advice and then chose to flow.
Where is it? First?
Paragraph
Milord,
13. Your Lordship.
page 44, Milord. At the top. Dubai.
There is no advice there in page 44.
Everything is normal. In
No,
terms of
Milord,
pregnancy. Pregnancy was of 11 weeks.
Yes. No, Milord, the handwritten one, Milord.
Page?
My
43 then.
43.
43 in our copy. Where is the advice?
Milord,
Absolute bed rest. 1st of August. Why absolute bed rest? What is the diagnosis?
Diagnosis on the next page, Milord.
Which of the doctors saw you? Among the left-hand side ones? Signed? Who has signed this? There is no signature. Swapun Rai? That is the counter signature, your counter signature.
That is not there.
You can't look into this.
Even if, Milord, definitely there has been latches, Milord. After that, I went back to Dubai. But that cannot overweigh, Milord.
Entire demolishes your case of your being
non-service of summons.
We don't look at that. We can't go to that. Because for the latter period, you have failed to explain.
Definitely.
If you don't condone that, we take it from the date of your knowledge. We believe everything which you said. But then from the date of knowledge, you spent 1 year. And your only ground is demolished by your flight to Dubai. Only ground is that you are advised bed rest on 1st of August, right? So if you go to Dubai by flight and come back in September, Then you demolish your own case. There is no subsequent doctor's certificate.
There is no.
So you are advised bed rest and you merrily go to somewhere else. And a serene and calm place like Dubai.
No, she used to stay with the husband. And I cannot improve on that, Milord. My passport is also annexed, Milord. It can be easily revealed. But there was no service of summons at all.
Even if you believe, we'll have to say that the other aspects.
Well, in this case, Milord, lenient approach should be.
Why?
Why, Milord?
You have tried to mislead the court, Mr. Bhattacharya.
Why, Milord? There is a.
You have tried to mislead the court. Your client has tried to mislead the court. Your client says that she's using her conception as a shield for Section 5.
Milord, kindly appreciate one thing. The child was born.
You are citing your child, the advanced stage of pregnancy, so-called, and you fly to Dubai after being advised bed rest.
Here, Milord,
Why do you cite your child for all these things?
Consequences, Milord, are different.
What consequences?
Consequences, Milord, the child was born after divorce. Milord, paternity will be a question. It's not a case, Milord, child was born during the Milord subsistence
That has
of the
specifically been stated here. Sympathetic grounds,
Here
other
is the Milord
consideration,
legal consequence.
equitable. No, equitable. What legal consequence? This is not a legal consequence vis-a-vis the Section 5. This is a legal consequence which will follow.
The child.
Then for us it will be a sympathetic consideration, which has been curtailed now. Specifically curtailed. Sympathetic consideration, equitable considerations, considerations of otherwise justice, equity can't come in now. Here we have left no. If there was some other ground cited, we could have still thought about it. But you don't leave any option. You take the bed rest route and then show a certificate which is of August and you fly to Dubai in September. So you demolish your own case by that flight. Why you last stayed together when?
Milord, kindly comes to Milord.
Why are you saying repeatedly that now you're raising suspicion in our mind?
Yes, kindly comes to Milord. The first Milord few paragraphs.
Child was born on March 25.
Yes, sir.
March 14th March.
2025.
2025. So why do you say the paternity will be in doubt?
Milord, the decree was passed on
16th October 23.
to 16th October 2023.
Why should the paternity be in doubt?
Milord, after Milord the dissolution of marriage, because their ground is of Milord.
Child
adultery.
is not illegal.
Their ground in the suit is of adultery.
So that we cannot help you, Mr. Bhattacharya. Cannot help you on that. You can't legalize something which we don't know is legal or not. You're being very rude, but you have to say this. We can't, just like we can't normalize which is I mean, we can't shunt out something which is legal, but we can't legalize or validate or rationalize something which you don't know, we are saying, which is legal or not. You admittedly came to know when you came back from Dubai. No, sir. Sorry. We understand the consequences, but very difficult for us to swallow this. কি করব? মানে এখানে একটু বেড রিসার্চ পরিষ্কার দেখাচ্ছে। সুটটা ইলিগাল ইয়েটা নিয়ে বেরিয়ে গেছে। ডিগ্রিটা নিয়ে ফালতু বেরিয়ে গেছে। এই এক্সপ্লেনেশনটাই থেকে বেরোবো কি করে? জাজমেন্টগুলো এখন স্টিয়ারিং অ্যাট অফিস। এটা এখন তুলে এখন দেখা। কারণ এই গ্রাউন্ডে কি করে অ্যালাউ করি বলুন তো? তারপরে বসেছিল। Sorry. By your previous order, we had directed the application for condonation of delay in preferring the appeal to be listed along, please take your seat, to be listed along with the appeal, comma, in view of some of the issues involved in both being identical. Full stop. However, comma, there are certain disparate DISPARATE issues as well, which we will discuss as we go forward. Full stop. Next para. The ex parte divorce decree, comma, obtained by the respondent husband under the Special Marriage Act, comma, was passed on October 16, 2023. Push up next para. As per the appellant's case, no, sorry, as per the appellant, the appeal, comma, however, comma, was filed on May 23, 2025. Push up next para. The appellant's case in the condonation application is that she came to know of the divorce decree in the month of October 2024. However, comma, since she was at an advanced stage of pregnancy at that point of time and had been advised bed rest, comma, the appellant could not take any steps for preferring an appeal against the said decree. Next para. Ultimately, the appellant gave birth to a son on March 14, 2025. Only thereafter, comma, in the month of May 2025, comma, after recovering somewhat, comma, the appellant could take appropriate before that you to no, appropriate could take appropriate steps for preparing the appeal. Next para, learned counsel for the appellant submits that the period between the appellant first coming to know of the ex parte decree and the date of passing of the decree is easily explained by dint of the fact that the appellant could not have had any knowledge of the suit or the ex parte decree at the relevant period. Next para, in support of such contention, comma, learned counsel places reliance on certain orders passed in connection with the suit, comma, on the basis of the certified copy of the order sheet annexed to the memorandum of appeal itself. Next para. For example, comma, vide order number 5 dated September 19, 2023, comma, it was recorded by the learned trial judge that one acknowledgement due was received along with sealed envelope with a postal remark unclaimed, comma, on the basis of which the learned trial judge proceeded to record that the the present appellant within bracket respondent in the suit bracket closed had refused to sign the service return. In the self same order, comma, the learned trial judge also relied on a report filed by the process server. Next para. The said report of the process server is also placed before us. Next para. From the same, comma, it transpired that the summons were allegedly served on June 28, 2023 in the presence of certain neighbors of the present appellant. However, comma, learned counsel points out that the address of the witnesses, comma, depicted in the said report, comma, do not tally with that of the appellant, comma, as mentioned in the plaint. Next para. That apart, comma, from the process server's report, it is clear that a lady with a mask, a lady wearing a mask had been passed off as the appellant, comma, which itself, comma, it is submitted, comma, creates suspicion. Next para. Learned counsel places reliance on the endorsement on the passport of the appellant, comma, from which it appears that the appellant was out of India during on that date when the summons were allegedly served. Next para. From the endorsement in the passport, comma, extracts of which are annexed to the to the condonation application, comma, it appears that the appellant had departed from India on October 28, 2022, and thereafter returned to India on September 19, 2023. Full in view of the summons having been allegedly served in the interregnum, comma, it could not have been served on the appellant, comma, nor could the appellant have refused to receive the same, comma, as sought to be made out in the bailiff's report. Next para. Secondly, comma, it is argued that the only address of the appellant given in the plaint is that of the alleged adulterer, comma, with whom the appellant had an adulterous relationship in terms of the plaint. Next para. However, comma, from several documents, comma, including the passport, comma, the Aadhaar card, comma, ration card, and voter's identity card of the appellant, comma, copies of which are annexed to the condonation application, comma, learned counsel for the appellant submits that it is evident that the address shown therein of the appellant was her paternal address. Next para. Thus, comma, it is submitted that the summons were allegedly served on at an address where the appellant has never resided. Next para. That apart, comma, learned counsel places reliance on Order 5, Rules 17 and 19 of the Code of Civil Procedure within bracket as amended by the Calcutta High Court by this High Court's rules bracket closed, comma, in terms of which, comma, in the event the summons cannot be served on a particular person, comma, the same has to be affixed to a conspicuous place in the neighborhood, in the immediate vicinity of the address, and a copy thereof has to be returned to the court, comma, upon which the court is mandated to examine the process server. Next para. None of such paraphernalia, comma, as apparent from the order sheet of the suit, comma, were complied with by the learned trial judge. Next para. It is next contended by learned counsel for the appellant that under the Calcutta High Court's rules, under the Special Marriage Act, under the Special Marriage within bracket Calcutta High Court bracket close rules, comma, 1955, comma, under Rule 10 thereof to be specific, comma, in every petition for divorce on the ground of adultery, comma, the alleged adulterer shall be impleaded as a co-respondent. The power to frame such rules stems from Section 41 within bracket 2 within bracket small a of the Special Marriage Act, comma, which specifically stipulates such requirement in the statute itself. Next para. From the plaint of the present suit, comma, it is pointed out that there was no impleadment of the alleged adulterer at all, comma, thus vitiating the suit. Next para. As such, comma, since the suit itself was not maintainable, comma, it is argued that the decree passed therein was bad in law. Next para. Learned counsel appearing for the respondent husband submits that as per the admission in the condonation application of the appellant itself, comma, the father of the appellant had derived knowledge of the ex parte decree dated October 16, 2023 on September 20, 2024. Thus, comma, the contention in a subsequent paragraph of the condonation application that knowledge was derived first in the month of October 2024 is erroneous. Next para. That apart, comma, a gross discrepancy in the stand taken by the appellant is sought to be submitted before the court. Learned counsel for the respondent points out that whereas the appellant has pleaded and annexed a purported medical certificate to indicate that she was advised bed rest on in the month of August 2024 or 2024 due to her advanced stage of pregnancy, comma, she flew out to Dubai on September 14, 2024, comma, about a month thereafter, and returned on September 23, comma, 2024. Full stop. Thus, comma, it is argued that the plea of advanced pregnancy as a defense against the appellant's negligence falls flat. Full stop. Next para, if she could fly to Dubai after having been advised bed rest, comma, there was no reason why she could not prefer the appeal even 1 year or for almost 1 year thereafter. Full stop. Next para, learned counsel for the respondent submits that the arguments made on the maintainability of the suit and alleged non-service of summons pertain to the merits of the appeal, and as such, it would be premature for this court to consider those at this juncture. Full stop. Next para, learned counsel for the respondent cites the judgment of Pathapati বলে যেটা প্রথমটা Pathapati Subba Reddy, where the Honorable Supreme Court, comma, inter alia, comma, had considered several previous judgments in the field and had come to the conclusion that whereas Section 5 has to be construed liberally and in order to advance substantial justice, comma, a justice-oriented approach should be taken, comma, but the same cannot be used to defeat the substantial law of limitation contained in Section 3 of the Limitation Act. Full stop. The Supreme Court, the Honorable Supreme Court held that if sufficient cause had been explained, held that courts are empowered to exercise discretion to condone the delay if sufficient cause had been explained, comma, but that exercise of power is discretionary in nature and may not be exercised even if sufficient cause is established for various factors such as inordinate delay, comma, negligence, and want of due diligence. Push up. Next para, learned counsel further points out that the Honorable Supreme Court observed that delay condonation applications have to be decided on the parameters laid down for condoning the delay, and condoning the delay for the reason that the conditions have been imposed tantamount to disregarding the statutory provision. Push up. Next para, in support of the same proposition, comma, learned counsel also cites Balwant Singh within bracket dead bracket close versus Jagdish Singh and others, reported at 2010 8 SCC 685, comma, where the Honorable Supreme Court had observed inter alia that delay cannot be condoned if the same is directly a result of negligence, comma, default or inaction of a party. Full stop. Next para, thus, comma, it is submitted that the application for condonation ought to be dismissed at the threshold. Full stop. Next para, before going into the question as to whether the suit is maintainable, comma, which can only be looked into in the event the appellant crosses the threshold hurdle of delay, comma, we are to focus first on whether the appellant could sufficiently explain the delay occasioned from the appellant allegedly coming to know first of the ex parte decree as per her own pleadings and the filing of the appeal. Full stop. Next para, as mentioned earlier, comma, the ex parte decree was passed on October 16, 2023, and the appellant's father first came to know, the appellant's father, comma, who was looking after the case for her and inquired with the advocate concerned, comma, first learned of the same on September 20, 2024. Full stop. Next para, therefore, comma, when the appellant returned from Dubai, comma, which is her own case, comma, on September 23, 2024, she must have been posted with the fact of such ex parte decree. Full stop. Next para. However, comma, no plausible explanation apart from the advanced pregnancy of the appellant has been put forth to explain the huge delay between September 23, 2024, when the appellant returned from Dubai, and May 23, 2025, when the appeal was filed. Full stop. Next para. With regard to the second such reason, comma, we also find it difficult to accept such cause. Full stop. Next para. From the purported medical certificate, within bracket, it is to be noted that the same is not countersigned by the appellant herself as per the law, bracket closed, comma. In the month of August 2024, comma, the appellant was advised bed rest, comma, apparently due to the detection of a second pregnancy. Full stop. Next para. However, comma, by flying to Dubai about a month thereafter on September 14, 2024, comma, the appellant threw out of the window the said ground. Full stop. The ground of advised bed rest is demolished by the appellant's own admitted conduct of having flown to Dubai in September on September 14, 2024, after having been advised such bed rest in August 2024. Full stop. Obviously, comma, the appellant was not in such a condition on September 14, 2024, comma, that she would still have to adhere to the purported advice of bed rest given 1 month back. Full stop. Next para. Thus, comma, it is not possible for us to believe the contention of the appellant that due to her advised bed rest due to advanced pregnancy, comma, she could not prefer the appeal in time. Full stop. Moreover, comma, the appellant returned from Dubai on September 23, 2024. Full stop. As per the pleading in the condonation application, comma, the appellant was in an advanced stage of pregnancy and had to take bed rest from the month of October 2024. Full stop. However, comma, in view of the above observations, comma, there is no further medical certificate to support such contention. Full stop. Next para. That apart, comma, the son of the appellant was born only on March 14, 2025, comma, that is about 6 months after the detection of pregnancy. Full stop. Next para. Thus, comma, we cannot also accept the contention of the appellant that she was in such an advanced stage of pregnancy that she could fly to Dubai but could not contact an advocate next door. Full stop. Next para. In such view of the matter, comma, we find that the appellant was grossly negligent and inactive insofar as the preference of the appeal is concerned, comma, at least between September 23, 2024, comma, when she returned from Dubai and already had knowledge of the ex parte decree, till May 23, 2025, when the appeal was actually filed. Full stop. In the absence of any such explanation for the said delay, comma, the rigors as set out in the cited judgments squarely apply. Full stop. Next para. Although in Pathapati Subba Reddy Supra, comma, a line of distinction has been drawn between section 3 and section 5 of the Limitation Act, comma, the latter, comma, being held, comma, is to be construed more liberally, comma, still, comma, the Honorable Supreme Court categorically observed that the discretionary relief may not be exercised even if sufficient cause is established, if there is inordinate delay, comma, negligence and want of due diligence, comma, the last two of which are utterly absent in the present case. Full stop. Next para. That apart, comma, it was also cautioned by the Honorable Supreme Court in the said judgment that merits of the case are not required to be considered in condoning the delay. Full stop. Although such proposition is contrary to the previous judicial view taken in several judgments of the Honorable Apex Court, comma, in view of the subsequent modified view as expressed in Pathapati Subba Reddy, comma, we are bound by the said principle and cannot look behind the period of delay. to look at the merits of the service of summons or the other irregularities in the suit pointed out by the appellant. Full stop. Next para. In the matter of Balwant Singh within bracket dead bracket Supra, comma the Honorable Supreme Court had also observed that once a valuable right as accrued in favor of one party as a result of the failure of the other party to explain the delay by showing sufficient cause and its own conduct, comma, it will be unreasonable to take away that right on the mere asking of the applicant, comma, particularly when the delay is directly a result of negligence, comma, default or inaction of the party. Full stop. Next para. It was observed that liberal construction cannot be equated with doing injustice to the other party. Full stop. Furthermore, comma, in the aforesaid judgments, comma, the Honorable Supreme Court also issued a caution against allowing condonation applications on sympathetic grounds alone, unless the delay is sufficiently and convincingly explained. Full stop. Next para. Thus, comma, following the above propositions, comma, we are of the opinion that the appellant has miserably failed to show her bona fides and or to explain away her gross negligence during the relevant period between September 23, 2024 and May 23, 2025 when the appeal was preferred. Full stop. In such view of the matter, comma, can 1 of 2025 is dismissed on contest without any orders to cause. Full stop. Accordingly, FAT 259 of 2025 is dismissed as time barred. Full stop. Can 2 of 2025 stands disposed of consequentially. No orders to cause. Urgent certificate copies. Sorry, yes. He argued very well. Yeah. এই বইটা সৌনককে ফেরত, এটা আমাদের বই, এটা ওদের না, ওকে, বইটাও রেখে দিলাম, মামলাটাও। ইয়েস, থ্যাংক ইউ। এটা 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 একটু একবার দিন তো, ফাইলটা আগের ফাইলটা, এই ফাইলটা ওটা শিটে একবার দিন, ওটা শিট।
মেমোটা আর এটা হচ্ছে ক্যানটা।
ভালো। নাম ইয়া গায়ন স্পেশাল অফিসার প্রফেসর অ্যাপয়েন্ট করতে হলো। এগুলো ঢুকিয়ে দিন, এগুলো শেড করে দিলে হবে। Yes, next.
Item number 4, I am for the appellant petition. There is a defect that deficit court fees of 50 is there. I shall put in the deficit court fees by tomorrow.
50 rupees. Yes. You should have put in by yesterday.
Yes, that should have been.
Yeah, what is the matter, Mr.
In a suit for
It's
divorce.
got an order that the appellant shall put in the deficit court fees by tomorrow. By tomorrow. Yes.
In a suit for divorce on the ground of desertion and cruelty, the court decreed the suit on the ground of cruelty. Desertion has not been granted. Now, against that, I have prepared this appeal before your Lordship's court. Now, I have filed an application for stay so that
What is your main ground, Mr. Rai? Just satisfy us prima facie.
The cruelty, as has been said, is the husband could not prove that cruelty. The learned judge discussed about the judgments of Dastane and others, but in reality, when the reasoning is given, my case has not been elaborately considered. If you losses kindly see the up to page 8 of the judgment, internal page 8 of the judgment, the learned judge has discussed about the principle of cruelty and ultimately held that the
will break down. That is a good ground now.
Yes.
Anyway, first appeal. The present appeal has been preferred against a decree of divorce on the ground of cruelty. Full stop. Next para. Since questions of fact and law are involved, comma, we find that there is a prima facie case for hearing the appeal on merits. Full stop. Next para. Although a prayer for stay has been made, comma, taking into consideration the fact that the judgment was won in rem, comma, we do not pass no, we are loath to pass an order of stay. Full stop. However, comma, the respondent shall remain restrained by an order of injunction from contracting any remarriage, comma, if not already contracted before today, comma, till disposal of Can 1 of 2025. The appellant shall serve a copy of the application on the respondent, indicating that the same shall be listed for hearing next in the monthly list of March 2026. Full stop. The appellant shall file an affidavit of service on the returnable date.
I'm good.
Next.
Number 5.
I'm for the appellant.
I'm for the respondent number 1 and 2, my lord. I have no copy, my lord.
You lodged a caveat?
No, I'm not the cabin.
Then you are not entitled. What is the matter?
Lordship, the suit for the, I am for the plaintiff and appellant lordship, suit for the partition and declaration. Learned court was pleased to.
Have you got an extra copy? Give him a copy right now. You have challenged a preliminary degree.
Preliminary lordship.
Usual order will be passed. Give him a copy.
Get full.
Usual.
Don't have an extra copy for service.
Extra copy, no lordship. Within tomorrow lordship, the matter is fixed.
No, not tomorrow. We'll dispose of the application. Yes, we'll pass the usual order that final degree proceedings will continue. We'll direct you to give a copy immediately.
As your lords. As your lords.
You are for
respondent number 1 and 2, my lord. I'll vocalatma with the government.
Then it has to. We cannot dispose of the application.
Right.
Very well. Since the respondent numbers 1 and 2 are represented by their learned advocate, comma, a copy of the application be served on the said learned advocate by tomorrow by the appellant. And a receipt in that regard shall be filed on the returnable date. Full stop. Next para. The appellant shall also serve copies of Can 1 of 2025 on respondent numbers 3, 4, and 5, as well as pro forma respondent number 6. You also serve on the pro forma respondent because it's a partition suit.
Yes.
As well as pro forma respondent number 6, indicating that the application shall next be listed in the monthly list of March 2026. Full stop. An affidavit of service to that effect shall be filed on the next date when the matter is called on for hearing. So next para. The learned trial judge shall continue with the final degree proceedings, but shall not draw up a final decree without the leave of this court till disposal of the application. Full stop. The appellant shall put in the postal cost, requisites, and written up notice form for service of notice on respondent numbers 3, 4, and 5, as well as pro forma respondent number 6 within a fortnight from date. Stop. Service of notice of the appeal on the respondent numbers 1 and 2 are dispensed with in view of appearance. Full stop. Next para. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited also within a week, within a fortnight from date. Full stop. The trial court, however, shall be entitled to retain skeletal records for continuing with the final degree proceedings. Full stop. Next para. Now we have already directed the application to appear in the monthly list. This is yes. Serve copies on him and them, and file an affidavit of service for them. Receipt regarding him. Thank you. Next. Yes, Mr. Vanu.
By the second order, Lord,
How are you now? You are ill on the last occasion.
Lordship, yes.
How are you now?
All
Better.
right.
Yes, Mr. Praj.
Lord, sometimes, Lord, we have to go to that, Lord, take up.
Oh, right.
And that date has been, Lord, was given yesterday.
No, you learned junior said.
Lord.
Yes. Not that, but you are in.
Lord.
What is the matter, Mr. Banerjee?
Lord, this is a matter, Lord, partition suit.
No caveat.
No caveat. Lord, partition suit. Lord,
dismissed.
Dismissed.
What is the
Lord,
ground? Why dismissed?
Two grounds. Lord, first ground is that after amendment of the plaint, service was not effected to the amended plaint upon the defendants, because even after the appearance by the defendants contested the suit, contested the suit. Lord, they contested up to injunction application. Then injunction application was allowed on contested hearing. Then they appeared. Practically, it was ex parte.
You were
So
the
why
plaintiff.
practically? Ex parte. Hearing was ex parte. Place for ex parte hearing.
Yes.
Against all.
So
Now,
it was
Lord,
dismissed. One of the grounds was that no copy of amendment plaint was served.
that ground it cannot be dismissed.
So what is the other ground?
Other ground, my lord, is that by two deeds, my lord, I have purchased the property, 270 and 71 and 72, 1.16 acres.
Yes.
Now, my lord, 1.16 acres, 270 and 71, you ought to have decreed in part because the deed was a marked exhibit and
Other
title was
portions you
proved.
failed to prove your title.
Court said failed to prove my title. Lord, because of the reasoning, Lord, by amendment, by the proposed amendment.
You are directing to serve copy of the applications and grant.
No, your lordship directed earlier. Lord, we have served the earlier injunction was also granted. And thereafter, in second time, your lordship has been pleased to direct me to serve copy.
Second time it has been served?
Second time it has been served. Lord, only difficulty is the service affidavit.
What is the difficulty?
Lord, affidavit of service. Lord, affidavit of service, my lord, your lordship kindly look to that only the last man, that is respondent number 6. Lord, page 14, my lord. Lord, page 14 said no such person in the address. Lord, page 14 of the affidavit of service.
Did they appear in the trial court?
They appeared in the trial court.
On that address? From that address?
They contested up to injunction.
On that address only?
On that address only. And my lord, I have given, my lord, your lordship kind.
Which respondent?
Lord,
regarding
Lord, respondent number 6.
The others have been served.
Others have been served.
Affidavit of service filed today be kept on record. First of, we find that only the respondent number 6 could not be served as she was apparently not found at the address. First of, however, we are apprised by learned senior counsel for the appellant that respondent number 6 had appeared from the said address in the trial court. First of, accordingly, we deem the service to have been properly effected on all the respondents. First of, can 3 of 2026 is allowed, thereby restraining the defendants stroke respondents from
changing blood,
transferring,
changing the nature and character of the property.
Transferring, alienating, encumbering, and or creating any third party interest in respect of the suit property, as well as from changing the nature and character thereof, or making any construction on the suit property till disposal of the application, till disposal of the appeal. First of, the parties shall maintain status quo as regards their respective possession in respect of the suit property during the pendency of the appeal. Full stop. We are intending to dispose of the appeal along with the application.
Dispose of the appeal
No,
only.
but they are not appearing.
41 Rule 27.
But we cannot do that because they are not appearing. What can we do?
Not only that, my lord, I have kindly called for a report from the department, Lord, because I have already, because in terms of your lordship's earlier order, I have already submitted Tolobana for the purpose of calling for the records. A special messenger cost I have deposited. Special messenger cost I don't know. Special messenger cost was also deposited.
When did you direct the special messenger cost? You never directed. Oh, yes. Only Tolobana was directed.
Tolobana was directed.
Special messenger cost was not directed. You never directed special messenger cost. Tolobana was directed.
I am changing your lordship by looking into that.
No. Tolobana দিতে বলেছিলাম কোস্টাল কোস্ট Tolobana দিতে বলছে Anyway, the trial court record shall be brought by special messenger at the cost of the appellant, to be deposited within a week from date.
Yes, Lord, this is the, we
comma,
have,
if not already deposited, full stop, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, full stop. Since learned senior counsel apprises us that the appellant has already deposited Tolobana and postal costs as well as written up notice form for service of notice of the appeal, comma, no further direction is passed in that regard. The parties will be at liberty to mention the appeal for enlistment as and when the same is ready for hearing.
and Lord, this is the receipt, my Lord.
Keep it with you.
from the
We have
department.
recorded your submission.
Lordship. Lord, third application, Lord, application 3, can number 3.
What is that?
Lord, this is for the purpose of direction upon the police authority not to make any construction on the property.
Police
They are
authority
in
will not
violation of the order. I have filed an application for implementation of the injunction order.
Police authority, why?
Yes, my Lord, your Lordship kindly come to can 3. Because respondent number 1 is making construction, not others. Lord, others are not. And Lord, I have given a specific averments, my Lord, also.
No, can 3 is the injunction application.
Yes, no, can
what?
3, Lord, can injunction application is, my Lord, can 2, my Lord. Injunction application is can 2.
Can 2 tell.
And this the application is for implementation of the injunction
Served
order.
a copy of can 3 also. You served a copy of
No,
can
I
3.
have not served the copy of can.
The appellant shall serve copies of can 3 of 2026 on the respondents, indicating that the same shall be listed on March 16, 2026, when an affidavit of service shall be filed to that effect.
In the meantime, my Lord, they should not, because they have
Injunction is there.
already raised certain constructions, my Lord.
In the meantime, injunction is already there.
Injunction is there, but police authority are not
In
looking
the
into
meantime,
this.
how can you grant police help without hearing them? Next.
Lord, then your Lordship is fixing for hearing of this
Application only. The rest of the deductions remain.
Lord, in the
bring the trial
15 days, my Lord, 15 days early. So that, Lord, we can serve the copy to them.
What 15 days?
The application.
We have fixed it on 16th of March.
16th of March.
We'll make it earlier.
Earlier, my Lord. So that we can.
Very well. তাহলে March 16 যেটা বললাম না ওটা হবে February 23, 2026.
Lordship, I'm deeply honored.
Yes. Who is appearing in 7?
Sir, in this matter, I'm appealing for the appellant. There is a
copy service.
Both are refused. Before the court will also there is expertise dismissed. Suit dismissed expertise. My lord will find
the appeal is against
the dismissal of the suit for partition. On the ground, defect of parties and unable to, my lord, 8 and 10, my lord will find the refusal.
Affidavit of service filed to be kept on record. Who served despite service, none appears for the respondents.
Refused, my lord.
Despite service, none appears for the respondent. আচ্ছা ঠিক আছে তার আগে একটা লাইন অ্যাড করি despite service এর আগে from the affidavit service filed to be kept on record বললাম from the same it transpires that the service has been refused by the respondents which we deem to be good service. Full stop. None appears at the time of call on behalf of the respondents, although the appellant is represented through counsel. Full stop. Next para. The present appeal arises out of the dismissal of a suit for partition. Full stop. We find a prima facie case having been recorded to have been made out in our order dated January 5, 2026 and do not find any change of circumstances. Full stop. Accordingly, we make the injunction and status quo order granted on January 5, 2026 absolute. Full stop. Accordingly, can 1 of 2025 is allowed, thereby restraining the respondents and or their men and agents from transferring, alienating and or dealing with and or creating any third party interest in respect of the suit property to disposal of the appeal. The parties shall maintain status quo as regards their respective actual physical possession in respect of the suit property, comma also till disposal of the appeal. The appellant shall put in due requisites, postal costs and written up notice forms for service of notice of the appeal on the respondents within a fortnight from date. The trial court record shall be brought by special messenger at the cost of the appellant, comma also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Here for two.
My lord, item number 8, I am appearing behalf of the petitioner, my lord, led by Mr. Dipendu Chatterjee.
Yes.
I am appearing on behalf of the petitioner, my lord, led by Mr. Dipendu Chatterjee. Is engaged before another court, my lord, praying for not today.
No, no, sorry, refused.
Then, my lord, praying for short pass over.
No, no, you move the matter. We are making your whatever order we passed on your application, we are making that absolute.
My lord.
We are making this order absolute.
No, no, my lord.
Without
Yeah.
prior leave, continue with the final degree proceedings.
Yes, that order. I am enjoying an order of injunction. I am the plaintiff in the suit. Suit decreed in preliminary form. So I am enjoying an injunction by the trial court order itself.
We are not disturbing that.
Yes, regarding the other part, to proceed with, yes.
Only on the other part. Third learned counsel for
Only one thing, may I just point out, your lordship mold the prayer because the can 1 prayer portion, your lordship kindly see page 11. It's my duty, my lord, so kindly mold it because they have made a final relief that cannot be done.
Can 1 of 2025 has been couched to be 1 for cancellation and or setting aside the impugned judgment and decree. Full stop. Next para. Upon hearing learned counsel, thank you. Upon hearing learned counsel for the parties, we mold the relief and treat the application to be 1 for stay of the suit. Full stop. Next para. Since the present appeal arises out of a preliminary decree of partition, we dispose of can 1 of 2025 by directing the learned trial judge to continue with the final degree proceedings. Full stop. However, the learned trial judge shall not draw up any final decree without prior leave of this court till disposal of the appeal. Full stop. Next para. There will be no order as to costs. In view of the appearance of the sole respondent through his learned advocate, service of notice of the appeal is dispensed with, and the appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The trial court shall be entitled to retain skeletal records for the purpose of proceeding with the final degree proceeding. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Great.
Oh, my lord, everybody service kept on it.
আচ্ছা প্রথম লাইনে thank you. These small matters you move yourself. Take permission of your senior. Yes. Yes. What happened? The Dutiman Banerjee is leading you. Yes, Mr. Banerjee, what is the matter?
Yes. Suit for eviction, my lord. Decreed.
Against you, obviously. Against you, obviously.
Yes, my lord. Otherwise, this especially much. And this is an instant appeal and application was last occurred probably by
2G.
2G. Now, my lord, only one thing I need to
appeal application, yes.
Appeal and the application will be heard.
That is why, yes. Why shouldn't 2G apply? When did your predecessor die?
2010.
Suit of
my lord, 2016.
Whatever, yes.
Only one thing, my lord, one interpretation of the agreement.
The premises sentence একটা দিন তো ওপরেই আছে দীপঙ্কর. Yes. Interpretation of 2G?
No. Only the agreement, which was entered between. এই যে তুই বললি দর্শককে দিবি আগের দিন ওই যে এগ্রিমেন্টের কপিটা বললিন তো আগের দিনে দিয়ে দিয়েছে না না আমাকে দিয়েছে না দুটো কপি বলেছিল দর্শকের জন্য
You should file a substitution application for the building. ভুতুরে একটা এই বাড়িটা যেটা বেচারা লড়ে যাচ্ছে. Yes. You should leave the premises by yourself, Mr. Rai. Let him suffer his own building. To protect your fundamental right, you should be evicted from these premises. Right to life.
আমার একটা আছে
ছবিটাও তুলেছে এমন একটা অ্যাঙ্গেল থেকে দেখুন ইচ্ছে করে বিচ্ছিরি
আমি দিলাম তো দুজন
পার্ক স্ট্রিটে
only one thing মানে
This in Park Street. There are buildings in such condition in Park Street.
Yeah, it is that we don't.
The problem is we see only the exterior. The interiors are.
No, but how much rent do you pay? My learned brother is asking.
কত টাকা?
Answer him.
How much rent do you pay to ball, Larry?
What is the rent, Mr. Rai?
কত টাকা সেটা বল জোসেফ জিজ্ঞেস করছে কত টাকা দিয়েছি সেটা বলতে পারছিস না
Let's see the agreement you will find from there.
না এগ্রিমেন্ট
700 per month.
no it is that point of time now it is little bit more than that
What? 710. Yes, show us from the agreement. Quickly, argue. Finish it.
yes Manakali considers whether
Your agony. Yes.
whether this inclusion regarding the years and
Which clause should you look
at the top labor to landlord which expression unless excluded or repugnant to the context shall include his heirs executor administrators Manakali will find
Yes.
legal representative and assignees and the tenant which expression unless excluded by repugnant to the context shall include his heirs executor administrator legal representative. Now whether 2G will prevail or the clauses of the contract. If you logically consider the section first, I draw your logically attention to the provisions 2G.
Is there anything to the unless contrary to the contract in 2G?
No.
There isn't probably. That's the definition of tenant. In other places, there is it unless.
That is why when section 13, if you logically, I draw your logically section 13. Whether the statutory contract, whether it is debarred or 2G, by is a contract. It is a contract between the parties which is lawful.
How is it lawful?
Because there is no bar under the statute to induct a tenant, including I am
By
recognizing
operation of law, because see, statutory protection is granted to contract has expired upon their quit notice being the quit notice.
It includes that.
Now you are a statutory tenant, so you are governed by the statute.
Manakali consider it includes the heirship of the original tenant or also included to be tenant. That is what
you are no longer a contractual tenant after the eviction decree. You are a statute even before the eviction decree. After the quit notice was given, the eviction notice was given to you. Now you are a statutory tenant. You are governed by the statute, so contract does not prevail. Gone. Let us finish it.
No, with expression exclude by repugnant to the context and include his heirs, executor, administrator, legal representatives. Whether it comes within the definition of tenant or what is followed from
definition of tenant comes from statute.
Statute.
Nowhere else. Statute says you are no longer a tenant.
2G.
No. This does not help you even otherwise, Mr. Rai. You were tenants when the landlord died. So you got this moratorium period, 5 years or whatever. You got that moratorium period. But after that, you have been rendered trespassers. So, not that this is contrary to the statute. Anything else? The present appeal has been preferred by the tenant, the defendant stroke tenants against a decree of eviction passed on the premise that the appellants have been rendered trespassers by operation of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997. For sub next para, learned counsel for the appellant places reliance on the agreement of tenancy made between the predecessor in interest of the appellants and the respondent on March 4, 1982. Full stop. In the description of the parties as depicted in such agreement, comma, it is submitted that the heirs, comma, executors, comma, administrators, comma, legal representatives and assigns of the original tenant were included within the definition of tenant. Full stop. Next para. Hence, comma, it is contended by learned counsel for the appellant that in view of the said contract between the parties, comma, the present appellants, comma, who are heirs of the original tenant, comma, are protected from the rigors of section 2 within bracket small g of the 1997 Act. Full stop. Next para, learned senior counsel appearing for the respondent controverts such allegation and submits that since the appellant is a statutory tenant, comma, the provisions of section 2 within bracket small g of the 1997 Act would override the contention of the agreement. Full stop. Next para, upon hearing learned counsel for the parties, comma, we are of the opinion that the respondent is justified in arguing that the provisions of section 2 within bracket small g of the 1997 Act would override the definition of tenant as given in the tenancy agreement executed between the landlord and the original tenant. Full stop. Next para, after service of eviction notice within the contemplation of section 6 within bracket 4 of the 1997 Act, comma, the legal status of the tenant becomes that of a statutory tenant as opposed to a contractual tenant. Full stop. Next para, hence, comma, the appellants, comma, although entitled to the protection of the 1997 Act, comma, are simultaneously also governed by the provisions of the said Act and no longer under the contract. Full stop. Next para, viewed from such perspective, comma, section 2 within bracket small g of the 1997 Act operates in full swing. Full stop. Next para, the said provision is quoted herein below. 2g, 2 small g. Full stop. Next para. Even otherwise, comma, we find that there is no conflict between the description of the tenant in the agreement and the provisions of section 2 within bracket small g of the 1997 Act, comma, since section 2 within bracket small g recognizes the status of those heirs of the original tenant who are dependent who were dependent on him and were residing at the time of his death with the original tenant as heirs of the said tenant for the purpose of the Act. Full stop. Such tenants, comma, although initially recognized as tenants, comma, lose such status within the contemplation of clause small g of section 2 after expiry of 5 years from the date of death of the tenant. Full stop. Next para, it is well settled that since the 1997 Act is a beneficial statute and provides a cloak of protection to the tenants, comma, which is not otherwise available to them after cessation of the landlord-tenant relationship, comma, the rigors of the said Act are also equally applicable to the tenants, comma, since what is given in the one hand in the statute can also be curtailed by the legislature by the self-same statute. Full stop. Next para, in view of the above principles, comma, since it is an admitted position as that the original tenant died in the year 2010, comma, after the expiry of 5 years thereafter, comma, the status of the appellants, comma, being the heirs of the original tenant, comma, was rendered to be trespassers, mere trespassers. Full stop. Thus, comma, we do not find any error, comma, either of law or of fact in the impugned judgment. Full stop. Accordingly, comma, FA 465 of 2025 is dismissed on contest, thereby affirming the judgment and decree dated April 23, 2025, passed by the learned judge, comma, 5th bench, comma, City Civil Court at Calcutta in title suit number 1664 of 2016. Full stop. In view of the pendency of the appeal for so long, comma, the appellant is granted.
Yeah, to suit the appeal is so long. It is 2025 appeal.
Not of the appeal, litigation.
No, appeal for so long, comma, the time for vacating the premises given to the appellant is extended for 90 days from date. প্রথমেই একটা সবকিছুর আগে একটা করে দাও As per previous direction, comma, the appeal is taken up for hearing along with the connected application.
অত দূর আমি যেতে পারবো না।
Next para, ওটা হয়ে গেল প্রথমে আর শেষে করে দাও can 1 of 2025 is consequentially disposed of as well বলে ওই no orders to pass করে এটা ডিক্রি ফর্মে হবে এই জাজমেন্ট ফর্মে হবে।
আমি ওইদিকে
তন্ময় কোথাও একটা ঢুকিয়ে দাও কপি অফ দি এগ্রিমেন্ট ফাইল টু বি কেপ্ট অন রেকর্ড।
ডিগ্রি তো ড্রন আপ হবে,
ডিগ্রি ড্রন আপ হবে,
ডিগ্রি ড্রন আপ হবে,
হয় সই করতে হবে।
ডিগ্রি ড্রন আপ
ডিসমিস করলেও সেটা ডিগ্রি। এটা কোন দূর বাইরে তুমি চলো
ডিগ্রি টু বি ড্রন আপ কি হবে?
কিছু দেখতে হবে না, জজ বলছে দ্যাট ইজ সাফিশিয়েন্ট, নেক্সট কল করো। Yes.
In default, the degree be put into execution, my lord. My lord has given 90 days time. In default, the degree be put.
They have not levied execution. They have not.
No, execution levied.
How can you expect he?
Mr. Chatterjee is there. Everything will be there.
Mr. Chattopadhyay is there
Oh,
for execution. Yes. Yes, who is appearing in item 10? Yes, Mr. Basu. Nothing in it. Nothing in it. So many people are appearing. Mr. Basu, Mr. Banerjee, you are assisting, Mr. Oh, then it's all.
then something is there.
Maybe.
Joint effort kharab.
Yes, yes. Well, no, you are bhalo. He is kharab. Because if he led you, then it would be a bad word.
Impression.
In my learned senior friends appeal.
Justice Bhattacharya, kindly support me somewhere.
Only one Y. I have two Y's. Yes.
Before my learned senior friend opens up my lord argument, my lord, we succeeded in 711 from which my lord this appeal is preferred. My lord, the contention in our 711 appeal.
Tell Mr. Datta that it will be over soon.
He is with us.
Oh, he is with you. Yes. Now please continue. Yes. Whatever. 711.
Yes, 711 allowed
711.
on the ground. My lord, we filed the 711 on the ground that my lord, by filing this suit, they are trying to my lord, overcome a decree which has already been passed in a previous suit. Naturally, my lord, the decree passed in the previous suit, my lord, is a relevant document. That decree, my lord, has been annexed, my lord, to the appeal, but not in complete form. My lord, there was a map annexed to the decree which was passed in our favor in the previous suit.
Do they refer to the suit in the plaint?
Yes.
It is founded.
So, my lord, that map is extremely relevant. Which is missing. My lord, we have asked, my lord, our client, my lord, to get hold of.
Omitted documents we are directed, we are permitted to produce.
Yes. Really call for the lower court records, my lord.
You are permitted to produce the omitted documents to expedite.
Documents were when we additional documents which we relied upon, not part of the pleadings.
Achha.
But this is below the decree which is the basis of the plaint, relied upon in the plaint. But the decree which is there below.
You filed that along with the 711.
The decree is with the part of the plaint itself.
Not 711. It's a part of the record. That's why they are asking.
It's referred to in
The
the
decree
plaint.
has been relied upon. There is a part of the decree.
No, that decree, the complete decree has not been given or what? What has been omitted?
Decree annex আছে decree mapটা নেই
Give the map.
decree is the annex is there
Map is not.
decree the plaint is annex
What had happened is this, my lord.
mapটা
Yes.
The witness, I believe, my lord, the witness had from the box had identified a portion of the map.
And taken it away.
No. And my lord, that map was, my lord, has been mentioned in the decree. But that map I don't find.
Don't find means it was not a part of the record.
Part of the decree, but not part of this. Certified copy does not have. Certified copy. So we have applied.
Have you got a copy of that map?
No,
Exchange?
none of us. No.
He won't have.
ম্যাপটা নেই ম্যাপটা কোথায় ডিগ্রির সঙ্গে ম্যাপটা ছিল
ডিগ্রি কোনো ম্যাপই ছিল যে ডিগ্রি বেস
আরে ডিগ্রিতে ম্যাপের রেফারেন্স রয়েছে
ওটা পাল্টে দিক
ডিগ্রি ইজ পার্ট অফ মাই প্লেন্ট
ম্যাপটা ছাড়া
Plaint has been rejected.
ইয়েস প্লেন্ট হ্যাজ বিন রিজেক্টেড গ্রাউন্ড দ্যাট দ্য
ডিগ্রিটা বার কর আগে দে
If there is not a part of the record, then it is not there in the record.
No, it's there.
প্লেন তো আমরা অ্যানেক্স করেছি রে বাবা
উই হ্যাভ অ্যানেক্সড দ্য প্লেন্ট অলসো
দেখা ওরে
Where has it been referred to in the impugned judgment?
নো নাথিং
বলতে দেন না ওদের
প্লেনটাই তো লেখা আছে ডিগ্রিটা বার
If it was not a part of the plaint,
Plaint refers to a decree. My learned friend is claiming a
you
declaration.
can only look at the plaint unless you produce that map or whatever.
Document referred to in the
My lord, your lordship can look at the plaint.
Yes.
Documents annexed to the plaint. Documents referred to in the plaint.
Yes.
that's all
The decree was referred to in the plaint, and on the basis of the decree, this declaration is sought.
So the decree must have been looked at by the trial court.
The decree
The previous
has
decree.
the previous decree, yes. But my lord, that decree also contains a map
That is what you are saying, but it's not
from
reflected
the
anywhere.
decree itself. If your lordship sees, kindly see the decree. I have seen.
Judgment annex for
Because I
Decree
remember
was annexed. That decree was not annexed to the plaint, only referred to the plaint. How did the trial court get that decree? I mean, was it produced by you? That's what we are asking.
nobody.
Nobody produced, then
they
how
can
could it be a part
produce?
of the record?
How they can produce? 7-Eleven?
My lord,
No, but why not? Because if it's referred to in the plaint, at one of
I
the
produce, plain will contain that.
so you have produced the decree.
Decree annexed.
Previous decree.
Previous decree. That is the
Annexed.
previous decree.
So this is what was there, a part of the plaint. The entire plaint has been annexed here with the annexures.
Yes.
So no map was there.
no map was there.
Then how are you referring to a map?
But the map is part of the decree. Kindly see this, my lord. Map is
The
part.
handwritten decree was not annexed to the plaint. The judgment was annexed, not this decree.
Whatever was a part of before the trial court, we can look into
This
it.
was not before the trial court, but was referred to in the plaint.
No, whatever was there before the trial court, we can look
It
into.
has to be like, if your lordship is looking at the decree, then the entire decree has to be looked into.
Definitely.
So the entire decree, the decree refers to a plaint, it refers to a map.
But it might not have been a part of the decree. Physically, it might not be.
It is there in the decree. It's recorded in the decree itself.
Maybe recorded in the decree, but if it's not there, what can we do? How can we
It's
improve
part of the decree, my lord.
Sir, so if it was not there before the trial court, why should we look into it? It's a new document to us for the first time. Even if it is referred to in the decree but not annexed to the decree, what can be done? Whatever was there before the trial court, we look into that.
My lord, what is before the trial court is
Might be referred to in the decree but not produced in the trial court. Neither of you produced. You could have taken out a certified copy and produced the map. How can we improve that?
My lord, all I'm trying to say is that your lordship is not improving on any material which the learned judge has not seen.
The judge had seen the map.
The judge may not have seen the map.
Then
Judge
we
has
won't
gone
look
by
into
the
the map.
decree.
No. If the decree refers to the map, but the map is not physically annexed to the decree which is produced before the trial court, we'll look into the decree as it is without the map. Whatever was there, whatever the trial court saw, we'll see. We'll not add any document to that, Mr. Doctor.
But my lord, with respect, I may be entirely wrong. My lord,
Where do we get the map? Shall we find out the map? If you don't produce, they don't produce. What are you saying? Neither of the parties produced. You are saying we should look into the map. Where do we get the map? Do we enter into a roving inquiry or go to that court and find out?
No.
Where do we get the map? You didn't produce, they didn't produce. So where do we find out the map? Should we produce means? Who should produce? Tell us. It was not produced before the trial court by either of you. Who will produce before us? Should be seen, it will never be heard out then. What are you saying? If it was not produced by either of you, how can we get a copy of that map? Should be produced.
My lord, it was not produced by either of us, but both.
Have you got a copy of that map?
No, I only find it that map.
Very well, then we'll
I
proceed on
I have applied for a certified copy, and that certified copy we are supposed to copy.
Say that.
I
should have started with that.
Oh, I'm so sorry, my lord.
That is what you are asking. How do you get the map?
No,
if you have applied for a certificate, that is the first thing you should have said.
No, I thought, my lord, I was giving an impression that
No.
you got an impression as your lordship is calling for records. No, not that.
We are
I have
not.
applied.
We are not calling for the records. Why should we?
I'm asking the
We are
lordship.
not. That was played for me.
No, that
Mr. Banerjee said to call for the records.
I have.
That's what. If it was not there, what's it?
We
You
were
have
at
got a
cross
copy of
purpose.
the map. You can get a copy of the map within 7 days. We'll keep it after 14 days.
Yes.
Give a copy to them. We'll consider whether we should look into that.
Should you lordship consider the granting of injunction? I am in possession. Well, they are trying to take after the plaint is rejected. They are trying to take possession of that.
There was no injunction to start with, I believe.
In the suit, was there an injunction?
No.
Then
file, na?
we'll keep it after 10 days. We'll keep it after 10 days. Learned senior counsel appearing for the respondent 2 submits. What about the other respondent? 1? On FinCorp.
Both are failed.
Magma leasing. They have to be served then.
Already served.
The last occasion you recorded only 2. So in the slip it was written 2. You are appearing for both, you will record that.
No, আমার ব্যাক শিটে কিন্তু শুধু 2 লেখা।
I love. Advent continue.
Advocate record নেই? So you cannot appear.
both have. One of the caveat, one is caveat ছিল একজন আর স্যার বলছে।
Madam, my back sheet says will respond number 200. My
He'll get one fee. He'll get
Spell back sheet properly.
Yeah, but the problem, তুই অরিজিন সাইড এত কি করে হয়ে গেলে বুঝতে পারছি না।
Nothing. Come on, he's both sides. He's both.
Okay, বলি।
He's both sides. So Datta is more appellate than original.
No.
He does more appeals than original suits before me because I've never taken up suits.
That's right.
Learned Senior Counsel appealing for the respondent submits that a decree was referred to in the plaint of the appellants before the trial court. First up, a map was a part of the said decree but was not produced in the trial court. First up, next para, however, it is submitted that the respondents have applied for a certified copy of the said decree, which was referred to in the plaint, which also contains the map. First up, as the decree refers to such map, it is submitted that the map is required to be looked into for the purpose of complete and proper adjudication of the present appeal. First up, next para, upon hearing learned counsel, we are of the prima facie opinion that the complete decree, which was referred to in the plaint by the appellants themselves in the trial court, ought to be looked into before coming to a final conclusion in the appeal. First up, accordingly, to enable the respondents to furnish such certified copy, upon service of proper, upon service of advance copy of the same on the appellants, let the matter stand adjourned till we'll keep it after 2 weeks. February 18, 2026.
Can it be just next week, following week?
Yes, why not? February 25, 2026. When the matter shall be listed under the same heading. Full stop.
Hearing the
Let it be understood that the appeal shall be taken up for hearing along with the application in view of the short question involved. First up, in view of the appearance of the respondents to their advocate, service of notice of the appeal is dispensed with, and it is deemed that the appeal is ready as regards service. Full stop. Since the papers are substantially before us, calling for the trial court records is also dispensed with. Full stop. Other formalities also stand dispensed with. ওটা এই হেডিং এই থাকবে, অ্যাপ্লিকেশন হেডিং এ থাকবে, কিন্তু আমরা অর্ডার রেকর্ড করেছি, অ্যাপিলটা শুনুন।
বড় অর্ডার হলো
তাহলে জীবনে হবে না। No.
কি
please don't.
দয়ের অবতার।
Absolutely. We could not find any English translation, that's why. Now, avatar is also there in the English language, so, but in a different context. Yes, who is appearing in 11?
Yes.
Yes. What is your case?
My lord, affidavit in reply.
You are for the respondent. Respondent.
Respondent. I'm filing my affidavit in opposition.
Right. Opposition reply, yes. তোমরা ভুলে যাওয়ার আগে একটা রেকর্ড করো, affidavits in opposition and reply file to be kept on record. তারপর বলছো। Yes, what is the matter about?
My lord, prior to entering into the matter, my lord, I want a leave to file the cost. Actually, after the date was over, I went to file the cost for special messenger cost. My lord,
filed it now?
No, my lord, they did not take because there was no order. So if you extend the time,
Time for the time for depositing special messenger costs is extended for a week from date.
My lord.
Yes. What is the appeal about?
My lord,
today speaks for determination of occupation charge. My lord had already granted a stay of the my lord execution case.
So we'll hear them first on occupation charge. Yes, Mr.
We have claimed my lord 22,000 my lord page 70.
What is the locality? Which area of Calcutta? Shampookur?
Bagh Bazaar.
Bagh Bazaar. What is the police station?
Shampookur.
All that 2 rooms situated on the ground floor at premises number 6B, Kashimitra Road. Ground floor, Ghat Street, first floor and second floor, entire building is occupied by them.
Kashimitra?
Yes,
the Kashi Mitro Ghat Street, PS Shampukur, Kolkata 7,03,000.
Acha, very well. 2 rooms on the ground floor.
2 rooms on entire building they are Milord occupying.
How many rooms?
Yes, kindly comes to
How many floors and how many rooms?
Yes, 2 rooms. Kindly see the plaint Milord which is at Can 1.
2 rooms you are saying again?
Yes, 2 rooms on the Milord situated on the ground floor and Milord 2 rooms situated on the first floor. Kindly see Milord page 18 of Can 1.
Eviction decree on what ground? Trespasser? Why 2 separate tenants? Why?
No, entirely.
Part 1 and part 2 in the schedule? Your suit.
Yes, yes. Milord, they are occupying Milord the entirety Milord.
Anyway, so you have divided in 2 floors.
Yes.
Yes, according to you, what should it be?
22,000 per in my opposition. Milord, the report is given of the valuer Milord 22,000 and odd Milord.
For all the 4 rooms?
Yes, 17.
It's in an alley or main road? Kashi Mitra Ghat Street is not a main road.
Very near to Milord Ravindra Saroni.
Any other landmark? If there was, you'd say. As a 70 years old, that has been taken into consideration.
Yes. My learned senior friend is very known to Milord that area. Milord.
Then 44,000. If he lives there, then 44,000, not only. Yes, what do you say? They have given some basis. What is your reply to that?
My lord.
4 rooms, 2 floors.
My lord, this is I am not occupying the entire building because I am one of.
You are not occupying. We are recording. We will give him. We will direct him to execute the decree in respect of that. Which portion you are not occupying?
My lord, actually, it is my marital house.
Marital, parital.
Yes.
Which portion you are not occupying? Tell us.
My,
We'll execute the decree.
my lord, my brother-in-law is also staying at the said premises, occupying some of the portions, and I am on also. It is a gift done in favor of one person, which has been challenged by a
an
title suit.
eviction decree against you. Court had found that you were in possession and has granted eviction.
My lord,
saying that you are
originally, my lord, you will have to go into the first the decree, my lord. My lord, this is not a. There was a list during the pendency of the original suit, where with regard to my title, my lord. It was a gift in favor of one of my in-laws that has been challenged by a title suit. During the pendency of the title suit, the property has been
Who challenged that? Who challenged that?
My lord, my husband has challenged that. My husband was one of the co-owners of the building.
Is similar the order admitting the Milord appeal. My lord has recorded the facts. Milord.
Everything, my lord. My lord, during the pendency of the suit, the suit property was handed over to another party. That conveyance has also been challenged by another title suit. And thereafter, after my husband's demise, they have come up with this suit. They had purchased in 2011, but they have come out with this suit for eviction after 7 years, in 2018. I am not occupying the entire premises. I am occupying only 4 small rooms.
যে স্যুটটা যেটা নিয়ে হয়েছে অ্যাবেট করেছে সেটা কি স্যুটটা যেন ছিল এটা কি স্যুট আমাদের ডিড প্রিডিসেসর
Yes, but as of today, even if there was substitution, as of today, the gift deed, those gift deeds remain. They have not been set aside.
and subsequent
My lord, the evidence is going on.
did and
Yes,
subsequent
yes,
bequest
yes.
to my client.
The evidence is going on, my lord.
Maybe. But you have to pay occupation charges for this. You were in
My
occupation.
lord,
of
yes, I have also filed a
22,000 is reasonable.
My lord, it is my valuation has come to 10,115. My lord, only 4 rooms, that too in dilapidated condition. My lord, if you go through the my report,
What is this? 28,000, 28 lakh and one.
my lord, last part. Come to the last part.
Yes, page
My
14.
lord, yes. Therefore, the standard rent in respect of the flat is per year. This is per year divided by 12.
Acha.
That comes to 10,000.
10,115. And yours is which page?
Page 17, my lord.
20.
22,000 and odd.
My lord, what they are saying that I am occupying the entire building, that is totally a false story. My
You are
lord,
not
it will be.
occupying.
I am.
Which portion you are not occupying?
My lord, it is a co-owner's house. I have a part, only 4 rooms under my occupation.
How
That
can it
too,
be co-owners? Because it has already been handed over to them.
part has been sold out to them. Part has
Alcott
been.
finding is the entire property has been sold.
No, my lord. That is the thing, my lord. That is, I'm before you, my lord. My lord, I have filed the tax receipt also, where it is showing that the record is still in my husband's name and my brother-in-law's name. They have not purchased the entire building. If you come to the annexure, my lord, at 34, page 34 of the stay application, that is their gift deed.
We agree.
That is their
15,000. We agree on that. 15,000.
My lord, kindly
Your
come
10 is 20.
My lord, come to the deed.
We can. How can we assess?
My lord, stay application. The deed has
No,
been.
we'll extend the state till disposal of the appeal, but you have to pay occupation charges and from the date of the decree.
My lord, kindly, my lord, make it
15,000. 4 rooms in a
my
building.
lord, condition, my lord, come to the condition.
For the condition only, we are only imposing 15,000, which is a pittance. It is nothing. 15,000 for 4 rooms nowadays, nothing.
My lord, 2 rooms are unoccupied because these are everything is.
By an order dated December 1, 2025.
12,000, my lord.
12,000,
my lord.
By an order dated December 1, 2025, we had granted stay of operation of the impugned decree of eviction till disposal of the application. Push-up from the affidavit in opposition filed by the plaintiff stroke respondent, we find that a valuation report, annexed thereto, reflects that the fair market rent of the suit premises, which is comprised of 2 rooms each on the ground floor and the first floor of a property situated at Kashi Mitra Ghat Street, police station Shambazar, Shampukur, near to Robindra Saroni, which is a commercially viable thoroughfare of Kolkata, would be rupees 22,700. Who's up next para? On the other hand, from another valuation report, valuer's report, annexed to the affidavit in reply filed by the plaintiffs, by the defendant stroke appellant, the standard rent in respect of the property has been stated to be rupees 10,115.42 p per month. For sub next para, learned counsel for the appellant further submits that the property is extremely old and in a dilapidated condition, and as such, the said condition of the premises should be factored in while assessing occupation charges. For sub next para, since both parties have given reasonable estimates with regard to their respective versions of the market rent which the suit property could fetch contemporaneously, comma, we choose to strike the middle path by assessing the occupation charges at rupees 15,000 per month for the entire suit property. Full stop, next para. While doing so, comma, we take note of the fact of the age of the building, but simultaneously consider the location and the number of rooms, comma, spread over 2 floors, comma, which are the subject matter of the suit of the lease, LIS. Full stop, next para. Accordingly, Can 1 of 2025 is disposed of by extending the stay of operation of the impugned decree and stroke or any execution case, comma, if levied pursuant thereto, comma, till disposal of the appeal, comma, on condition that the appellant goes on paying rupees 15,000 per month as occupation charges as a condition of such stay. Full stop, next para. The first of such current payments, comma, for the month of February 2026 shall be made by February 28, 2026, and thereafter, comma, the current payment of installment for each month shall be made by the last day of the said month. Full stop, next para. The arrears of occupation charges at the same rate, that is rupees 15,000 per month, comma, from the month of the impugned decree till January 2026 shall be shall be paid to the respondent by the appellant by 3 equal monthly installments, comma, the first of which shall be paid by the end of February 2026 and thereafter by the end of each succeeding month till the entire arrears are cleared off. Full stop, next para. In default of any of the above payments, comma, the stay order shall stand automatically vacated without further reference to the court. Full stop, the above payments shall.
One thing can I show?
Yes.
Page 45 of the stay application.
What is that?
My lord, that is the memo of consideration. My lord, 3 lakh was a purchase value in the year 2011. My lord. He had purchased.
So I've crossed 13 years after that. No, why 13? 15 years. All such payments shall be made by online transfers at the account, comma, the account of the appellant, account of the respondent, comma, the particulars of which shall be communicated to the learned advocate on record for the appellant by the learned advocate on record by the respondent within February 9, 2026.
My learned friend had filed 2 applications, Can 3 and Can 2. My lord, kindly pass direction for filing affidavits. One is an application under Order 41, Rule 27, and another is, my lord, a very peculiar prayer, Rule 25 for remanding the suit, my lord, virtually allowing the appeal.
That has to be heard. Both have to be heard along with it.
Along with the affidavit.
The application, Can 2 of 2025 is that 4127?
25. Order 41
Can 2 of 2025 is an application, comma, purportedly under Order 41 Rule 25 of the Code of Civil Procedure, seeking a remand of the matter to the trial court. However, comma, in view of the nature of the prayer made therein, comma, the same has to be heard along with the appeal. Full stop, next para. Can 3 of 2025, comma, on the other hand, comma, is for production of additional evidence under Order 41 Rule 27 of the Code. Full stop. Similarly, comma, the said application is also to be heard along with the appeal. Full stop. Accordingly, Can 2 of 2025 and Can 3 of 2025 are directed to be heard along with the appeal. Full stop. Affidavits, if any, in respect of the said applications shall be exchanged before the appeal is taken up for hearing. Full stop. Next para. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. In view of the appearance of the respondent through his learned advocate, commas, service of notice of the appeal on the respondent is dispensed with, and the appeal be treated to be ready as regards service. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to mention the appeal before the learned liberty to mention the appeal as and when the same is ready for hearing. Yeah. কালকে ভাবছি অ্যাপ্লিকেশন কন্টিনিউ করবো শুধু 11টাতে হলো কালকে ফর টুডে লিখে দিন যে টুডে দ্যাট ইজ বলে ডেটটা দিয়ে applications will be taken up first. কালকে appeal hearing নেবো না application নামাতে হবে তাহলে application এক খাতা রুজ মেনশন করতে নিতে পারছি we'll continue with the applications tomorrow not the appeals for
Yeah,
tomorrow only.
Yes, yes.
Please do a whispering campaign to whoever are your friends
Do that.
because we cannot afford to take up the appeals till the applications
So many
several applications are pending. We cannot add new matters. That's for you.
Great.
কালকে থেকে যাবি একটা